Please along. Lordship, I beg to mention item number 55 of daily process. Lordship, I humbly plead for adjournment. Lordship, 2 weeks time may be granted. 55. I'm appearing for respondent number 8.
What about the petitioner? Have you taken contact?
Yes. We've informed the petitioner and they have taken their
The
consent.
fixed matter. You have taken contact.
Yes.
Item 55, the request from third.
We are saying, Lordship.
Very good respondent. I think that would have been- but it is that how-
Much obliged.
Maybe, but I beg to mention that for listing for admission, my lord. Very urgent matter of 2022, my lord.
What is the urgency?
An urgency, my lord, a stay order was there, but the stay order has been vacated in my absence, my lord. So this writ petition needs to be disposed of on an urgent date, on Monday, my lord.
On Monday. On 22nd.
My lord.
22nd.
Obliged.
May I please, Lordship? Lordship, kindly take this matter as unlisted motion matter for 2 days, Lordship. Matter is very urgent. Matter is related to the salary of the petitioner and other office staff, Lordship. Kindly take this as last motion matter.
Why? Salary.
Salary of the petitioner, Lordship, and the other office staff of the bill, Lordship.
Salary has not been paid.
Salary is increment is stepping up, Lordship. Kindly. Therefore, file this petition.
It's about Monday.
Lordship, it is filed on 14, Lordship. 14/5, Lordship.
It's up Monday.
Lordship.
May I please, your Lordship? Lordship, with the consent of other side, I beg to mention item number 25, Lordship. Agenda matter for the day, Lordship.
You're for
Petitioner, Lordship.
petition, right? 25.
Obliged.
I beg to mention for listing with petition, Lordship, in admission column, Lordship.
Admission. 24.
Lordship, I beg to mention from listing. This matter relates to family pension, Lordship. She has not been
24.
24.
May it please support your Lordship, I beg to mention item number 44 on the daily list. During the last hearing, while dictating the order, your Lordship had directed that the matter will be listed on 3rd of June. So we had accordingly advised our client and they're gathering the information to prepare the affidavit and reply.
44.
44.
In this matter, I am for the petitioner, Lordship. Lordship may fix it on also 3rd of June, Lord.
As
It was
earlier
supposed to come on
directed.
so 3rd of June, Lord.
Directed on 17/5.
Your Lordship, we replayed the proceedings which were live streamed and your Lordship had clearly directed that it was to be listed on 3rd of June.
It is submitted by both councils that the matter was directed to be listed on 3rd of June. However, the order sheet reflects that it is to be listed on 17/5. Accordingly, let the matter be listed again on 3rd of June. As
Okay.
submitted by both.
Deeply obliged.
May I please, your Lordship? Yes, I beg to mention for listing, my lord, my lord, the matter regarding transfer of the petitioner, my lord. Maybe on Monday, my lord.
22nd.
I beg to mention item 43 of today's daily. Respondent number 3 has filed an affidavit. We need to file a reply to that. 3 weeks time may kindly be granted.
43 item. You are for the petition.
Yes, Lord.
They adjourn for 3 weeks, enabling the petitioner by rejoinder.
Lordship, can a date be given?
File your rejoinder and you fix it.
Right.
My instruction is to withdraw the matter, Lordship.
MSP Bhattacharya and for report. Not appear. Any instruction? Yes. Does it say?
Basically, the presenting officer and the IO, they were transferred, and in their place, somebody else were actually appointed. That's why the delay.
What about the review? What about the review
Review, instruction, anything.
regarding extension of suspension? The D. Boral, Tamil advocate, submits on instructions that the delay in proceeding to the department proceeding was on account of transfer of the inquiry officer and presenting officer,
Presenting of
both or one.
both, you know.
Now new has been appointed
Yes, yes. The order is also there.
in stop place of the earlier inquiry and presenting officer. New persons have been, officers have been assigned, and therefore they will not be. So, Bora, however, does not have any instructions regarding the whether the review with respect of the continuation of suspension is permitted a week's time, complete with instruction, and revert back. Apprise the court. Let the matter be considered again on the 22nd of May.
Obliged, sir. Yeah, please, sir.
My lord, here we have not received the up-to-date instruction, my lord. In terms of order dated 10/5.
How much time you require?
Another 2 weeks.
Lordship,
New.
with my respect for the landslide lordship, many times time has been taken, lordship. Lordship may give a final chance to them.
The chief executive setting council elementary education renews its prayer for further time. Several documents were done. Final opportunity. For the divided on 29th, enabling the standing council to take as straightforward. In the event the instructions are not furnished, court may proceed hear the matter on the basis of reading the bill number.
Obliged.
Well, as per the earlier order, my lord, instruction was sought for, and I have received one letter from the headquarters Assam Rifles, but this is not a signal from 14 Assam Rifles. The concern in it, my lord, they have not received. Actually, on what date it is communicated, that they have not yet received, my lord. But they have said that it is communicated, and when communicated, it is 2024. So, my lord, I'm saying we let the notice be issued, my lord. I'll file a affidavit, my lord, if they are taking, my lord.
Complete instructions have not been. Mr.
B. Kumar.
B. Yes, sir. According to the copy, Mr. Transfer again,
All, my lord.
the way our copies not get furnished within a period of 1 to 2 days. My request is after the return. My lord, highly available.
Obliged.
The matter may be passable for a time being, lordship.
Time being.
Lordship.
Okay, time being.
May I please, your lordship. Lordship, just to draw your attention in page 59 and extra 13, lordship, similar order, lordship, filed by this honorable. My lord, my limited prayer is that in the light of this order,
Page number.
page 59, lordship, and extra 30, relevant portion is page 61, lordship. And the representation is page 58 and extra 12.
Yes, Mr. Karunik.
Yes, my lord.
I've done it now. Okay. Order dated equal to past it, the 8 3 where made it on a bit to by the
Quickly obliged.
Obligation.
My lord, earlier my termination was interfered with by this honorable court. Now, pursuant to that order, I have filed a writ petition wherein I have prayed for reinstatement and also subsistence allowance. There, your lordship has already passed an interim observation also. Now, my lord, they have again reiterated the same order. Most disturbing part is if your lordship will kindly come to page 53, my lord. Page 53, fourth sentence from bottom. Therefore, the termination order issued on 7/9/21 by the employer is justified and stands as it is. My lord, are they sitting in appeal over a judgment of this honorable court, my lord? This very order of 7/9/21 was set aside by this honorable court.
by which order?
Yes. Page number 39, my lord, it starts. And the operative portion is at page 44. Typing related. Page para 14, my lord. Accordingly, we interfere with the order, it's a typing mistake, my lord, of the Commissioner PND Assam by which the services of the petitioner was terminated, but grant complete liberty respondents to act against it in appropriate manner under the law. That means, my lord, you should start a proceeding, give him full opportunity, then you do whatever you like. Now, my lord, the show cause notice has been issued. Earlier, there was a show cause notice issued. Now, pursuant to the judgment, straightway they have passed the order, now which is impugned in this proceeding. My lord, recently there is a judgment of this honorable court, my lord, where in a similar circumstances, the honorable court has held, my lord, that Article 311(2) will be attracted.
You are a contract.
My lord.
You are a contract.
Contractor. If your lordship would kindly come to page 9, para 19. In the light of the allegation on which the service of the petitioner has been terminated, the Honorable Supreme Court of India in Purushottam Lal Dhingra reported in Sweden already held that even for terminating a temporary government employee, the principles of Article 1011 was required to be complied with. Similar view of the Supreme Court has also been expressed in the case of so-and-so, wherein it is reiterated that termination of service of temporary government servant without any stigma amounts to punishment which may not be made without an inquiry. However, it is specifically held that even as a temporary government servant, delinquent is entitled to the protection under Article 1011(2) of the Constitution of India, where the termination involves stigma or amounts to punishment. Therefore, the two cases cited by the learned counsel for the respondents do not help to espouse the cause of the respondent, and this case is found to be similarly situated with facts of sense. So, my lord, there is a clear finding, identical facts met.
Now, in the earlier judgment, was the show cause set aside? The entire
No,
procedure?
termination order was set aside. 7/9/21. Page 37 order, my lord. This was the order which was earlier put to challenge.
So this termination was not pursuant to any inquiry or
No.
nothing.
My lord, the understanding of the government of Assam is, since the appointments are contractual, therefore they can do whatever they like. That's not the law in my humble understanding, my lord. Chief knows that Beliappa's case, where Honorable Supreme Court said, my lord, the benefit of Article 13 extends not only to at the time of entering service, it extends to every phase.
My lord, a similar writ petition pertaining to termination of contractual employees was filed, Jan Saikia versus State of Assam. The judgment passed by the learned coordinate bench was, considering the fact that these contractual agreements are contracts which are determinable in nature. Therefore, my lord, as per section 14 of the Specific Relief Act, no relief can be granted to these contractual employees. Against that writ petition, my learned senior had filed an appeal, which is currently pending before the Honorable Division Bench, pertaining to termination of contractual employments as per the clauses of the agreement executed between the employer and the employee. So subject to the outcome of that writ appeal, my lord, all these cases will be dealt by the judgment of the particular division bench.
Now, where is
But
the
that facts in Jansaika is different in the sense.
Show cause was
There
given.
no show cause notice was issued. Straight away, my lord, the provision was invoked. And that is a debatable issue, my lord. Whether section 14C can be of the specific relief can be invoked in a service jurisprudence, my
That is
lord.
currently
We are not
pending.
dealing with any, my lord, immovable property rights of anybody.
Well, that is currently pending, and there's no stay order on that judgment. So court had equivocally held that.
where is the impugned order here?
Yes. Impugned order is at page number 51, my lord. And operative portion is at page 53. Earlier, a show cause notice was issued. We filed a written statement. Thereafter, that impugned action was taken. Now, straight away on the strength of the judgment, my lord, this order has been passed.
But let issue be noticed as on paper.
Sorry.
Let notice be issued on
Yeah.
today.
All the respondent.
All PNRD, my lord.
January 2024. Passed by the Commissioner PNR, whereby the termination order earlier issued on 7/9/2021 was held by justified. The representation submitted by for his brief statement against is rejected. Was it pursuant to any hearing?
No, my lord, just, yes, it was notified when we appeared and then this order was passed.
He had submitted a written statement. It is written in the order as well, my lord. Written statement. So he was
My lord,
given an
those were annexed,
opportunity of
those
hearing.
were annexed in the petition. My lord, when we say hearing, we mean an inquiry, my lord. Inquiry within the meaning of Article 10 and 11, that we say have not been complied with.
My lord, contractual employees are not temporary government servants. They do not hold any civil post. Discipline and appeal rules is only applicable to government servants who hold a civil post. The rules are very clear about it. Contractual employees are not holders of civil post. They don't come under the jurisdiction of the appeal rules.
The termination of the writ petition by the order dated 7/9/2021. While safe for this court by the commission by UPC number 59/2020 of by the order dated 11/2022. It safe termination order set and the respondents were directed were given liberty to see further terms of the show by bringing the same and while doing so the petitioner be given an opportunity to hearing and be allowed to use the relevant he so desired. Pursuant there, the petitioner appeared to the authority he submitted to see. However, on a date that the petitioner was asked to appear, the order passed reiterating that the order of termination 7/9/2021 to justify and his representation for reinstate the engagement that the dispute order is violating of the 11 Constitution.
And I'm very sorry to interrupt, my lord. Another coordinate bench of this honorable court, the order which we have annexed, has clearly held, my lord. If your lordship would kindly come to page 62 for a moment. Page 62, last two paragraphs. Situated thus, this court is of the unhesitant opinion that order of termination dated 30/10/21 is unsustainable in law. Therefore, same is set aside. Respondents are directed to reinstate the petitioner back in service from the date of receipt of the certified copy of the order. After reinstatement of the petitioner, it would be open for the respondents to proceed against him in accordance with law by serving proper notice indicating specific charges brought against the petitioner. In doing so, it will also be open to the department to place the petitioner under suspension pending trial and conclusion of the departmental proceeding. If so advised, however, in such an event, petitioner will also be allowed subsistence allowance. So meaning thereby, my lord, he is entitled to full protection of 311.
But in your case, you will not reinstate.
No, my lord, not reinstated, nothing done, only.
Was there a direction to reinstate?
No. Liberty was given to him to proceed by placing us under suspension.
Submitted that that's not been complied. The proper procedure required to be adhered to by the respondent authority. And the respondent department merely reiterated the order 7/9/2021 to be justified when the order itself said the idea proceeding by the it submitted that notwithstanding that the petitioner is contractually is to be granted the benefit of protection and a proper procedure is followed prior to each with nominee order terminating as will have civil conflict. That Mr. P. Hearing the respondent setting up submit that similarly, I think for a division bench. Yeah, so yeah.
Versus state of Assam.
State of Assam. Do you have the writ appeal number?
Well, they are the parties in that, they are the appellants. So do you have the writ number, or writ appeal number?
64 of 2024.
64 of 2020. That order is passed. Therefore, at this stage, the court may be heard that account. Mr. What do you want? You want an interim order?
Not to fill up the post, my lord. Independent.
Contractual employees do not hold any post. I mean, it's the
The
basic.
authority, till the next available date, the authority persuade. The review order dated 11th of January 2024 will not attempt to fill up the text. Shall be
Deeply obliged.
listed again. Tenth of June.
My lord.
10th of
10 June.
Standing counsel. May please your lordship.
Yeah.
One of the petitioner of her lordship was the former vice chancellor of Dismissal University. He has been receiving his pension for the last 18 years. But all of a sudden in January 2024, my lord, the pension was stopped without my lord giving any notice or any communication to the petition. The imprint order your lordship will find at my lord page 38. Page 38, my lord. Order dated 29/1/2024. Pursuant to the decision of the 116 Board of Management of the University dated 28/11/2023 by resolution number such and such, payment of pension in favor of Professor Pradeep Chandra Deka, former Vice Chancellor of this university, is kept in abeyance from the month of January 2024 until further orders. My lord, the reasons was not given, therefore the petitioner asked them to give the reasons by writing an application. The reply your lordship will find at page 43. This is a letter addressed by the registrar to the petitioner. With reference to the above, this is for your kind information that the Finance Committee of the University in its 64th meeting held on 2011-2023 discussed the matter of admissibility of monthly pension, family pension in respect of Vice Chancellor of the University. The committee observed that the pension is only applicable to employees appointed in substantive basis who joined prior to 1/1/2024 and governed under CCS Pension Rules 1972. What is the provision? They don't say, my lord. However, the post of Vice Chancellor of Tezpur University is a tenure post, and hence pension, family pension is not admissible to the incumbents appointed in such tenure post. After threadbare discussion, the Finance Committee, by resolution number such and such, resolved to take legal opinion, and thereafter the matter be sent to UGC, Ministry of Education, for necessary directives until a final directive issued by the UGC Ministry of Education. Payment of pension, family pension may be kept in abeyance. This was approved by the Board of Management of the University in its 116 meeting held on such and such. Now, my lord, two things they say here. One is that, my lord, it's a tenure post, and they want a legal opinion, and my lord, the matter be sent to UGC, Ministry of Education, for their directive. Now, my lord, while granting the pension, your lordship will kindly come to page 34.
Yeah.
This is an order of the my lord Tezpur University pursuant to clearance of the Ministry of Human Resource Development, Government of India, white letter number such and such. Administrative approval is hereby accorded for payment of retirement benefits to Professor Pradeep Chandra Deka, former Vice Chancellor, Tezpur University, as detailed below. Monthly pension, retirement gratuity, and my lord, the approval has been given by the Minister of Human Resources at that point of time. Now, my lord, some personal changes in the university, and all of a sudden they decide, but the decision also, my lord, is subject to the my lord, the opinion and my lord approval of the ministry. That approval is already there. And my lord, I am at least entitled to a notice from my lord January 2024. The pension, it's a matter of pension, my lord. It's not a bounty. And my lord, they have stopped it without giving me any opportunity.
So may come to page 82.
Yeah.
Clause 3.
approximate start the period of service rendered by him or her in the university beyond the age of normal superannuation shall not qualify for the purpose of pensionary benefit. Lordship, what happened when the present petition was VC? At that time, Lordship, the decision was taken, and he was the chairman of that meeting, and he was present in the meeting. And here's the rule: the resolution was taken, and it was reviewed by the present management, Lordship. I'll produce the entire record, Lordship, fixed on Tuesday.
My lord, they have reviewed it, my lord, after 18 years. And my lord, the approval of the ministry is already there, my lord. It's not that, my lord,
Proper notice. Why do you respond?
Lordship, fixed on Tuesday, I'll produce the entire record, Lordship. Lordship.
Unless you file a counter, you file
We'll file by Tuesday, Lord.
by Tuesday.
Yes, sir. Because Lordship, the financial implication is there, and the decision taken earlier was rehearse the rules.
no, my lord, if it is reordered rules, my lord, how do you, my lord, give the pension with the approval of the ministry?
That
They
was the
cannot now say that, my lord, I was.
Who has taken the decision earlier?
earlier, Lordship, the management council where the present petition was present, and he taken decision in his favor.
For grant of pension?
Yes, Lordship. Although he was not entitled to pension. I'll produce in the record, Lordship. Lordship, may peruse this. This is
No,
the
my
reason,
lord,
Lordship, it is with
Another aspect, my lord. They say, my lord, we are governed under the CCS rules, my lord, CCS pension rule. There is no provision, my lord, of withholding pension. Unless, of course, my lord, there is a disciplinary proceeding. How can the, my lord, pension be withheld?
He is objecting to your very claim to pension. That is not pension. Withholding of pension will come only when satisfy the court for he accepts the proposition that you
My lord, for 18 years, and that too with the approval of the, my lord, ministry in the center, my lord, they have given it. And now, my lord, without giving me any opportunity, can they stop it, my lord? This is why I am at least entitled to a notice. And this is, my lord, I have to survive.
here, Mr. K.
Lordship.
I am praying for a stay of that order, my lord. At least, my lord, the current, my lord, pension has to be given, my lord. How do I survive?
All the respondents.
Withholding. 5, 9 months. Pension. Payable. That down. And pay technically. Yep. Petition earlier taken. Contrary. What?
Yeah.
Contrary. As terms and conditions of service device and which create chemical by that service rendered and not qualified veterinary benefit. So you were appointed after retirement.
Yes.
No, my lord.
No, no, Lordship.
I was the, my lord, dean in the Assam Agricultural University. Initially, my lord, on Lian I came for about 1 year. Thereafter, my service has been, my lord, absorbed. My lord, I have annexed the documents. And my lord, whatever amounts, my lord, I was entitled to from Assam Agricultural University, that was also, my lord, deposited to Chancellor University, my lord. So entire liability was taken, my lord. That is reflected in, my lord,
During
page 27, my lord.
when did you use superannuated as what?
My lord, I was continuing as the Vice Chancellor till 30th of September 2006. So from my lord 2006, my lord, I'm getting the pension. Now, all on a sudden, my lord,
You were a dean,
my lord.
in agriculture. You came on here.
I initially came on lane, but my lord, the absorption, your lordship will
You
find,
are
my
absorbed
lord,
as what?
my lord.
You are absorbed as what?
My lord, that your lordship will find at my lord, page 27.
7.
Yes, please.
27 and 28, my lord. 27 is, my lord, it's a letter from the Registrar of the University to Assam Agricultural University, transfer of past service in respect of Professor Deka. With reference to the above, I am directed to inform you that the Board of Management held on 17/6/2005 agrees to absorb Professor Dr. P.C. Deka, Vice Chancellor, in the services of Tezpur University and accept his past services at Assam Agricultural University, Jorhat towards pensionary benefits at this university. You are therefore requested to kindly transfer his service benefit.
You are absorbed as what?
Vice Chancellor.
Vice Chancellor,
As a vice
my
chancellor.
lord.
During
No.
the currency of your tenure. I mean,
No,
service
my lord,
tenure.
after the, during the current of my tenure in, my lord, the Assam Agricultural University. Then, my lord, entire service was, my lord, transferred along with the payments that your lordship gets at page 28.
No, my query is,
My lord.
were you absorbed pursuant to your superannuation in the Tezpur University, in the Agriculture University, or
No, I was continuing.
you are continuing?
Yeah. I still had, my lord, job time by tenure.
Then
He was appointed as a Vice Chancellor in the university. I produced the entire record, Lords.
no, you was appointed.
As a Vice Chancellor,
What is the retirement age of the vice chancellor?
65.
60.
65.
65.
Probably 65. Well,
65.
okay.
So he was appointed prior to the age of 65.
Yes, fine.
So perhaps then this clause that you're pointing out at 82 may not be applicable.
No, Lordship, the Vice Chancellor post is a tenure post in the university.
No, these clause, referring to the clause which you pointed out, right?
Lordship, me pleased to see.
This is the period of service rendered beyond the normal age of superannuation.
That I'll clarify, Lordship. Next on Tuesday, I'll clarify everything.
Not on Tuesday, it will have some other day. 25th?
Lordship.
Let him come with an affidavit, my lord.
We'll file the affidavit along with the original records.
Sorry, not on 25th, 28th.
Lordship.
28th. Issue notice letter number 28th. It's KL years, the of the respondent, the way the you know, 3 days, 3 working days. Since Mr. KL has expressed urgency in the matter. Since both the councils have expressed urgency in the matter. Instead of 28 of May. Relevant reports have been said be produced, and the respondents are also eligible. File their affidavit. Pendency of the writ petition shall not be a bar. Release process the pension. What interim orders can be given? Can't give you any interim order at this stage. You're challenging the very order itself.
Yeah.
Staying the order will amount to giving you a final writ. All right,
Well,
prayer for interim will be considered on the next.
Okay. Much obliged.
Obliged.
My lord, total 12 numbers of petitioners before your honorable court, they are all ITI passed, my lord. They who has appointed batch wise, my lord, from 2007 to 2016. Initially, they were appointed as Sahayak, my lord, under APDCL, but after that, they are promoted junior grade. Now, my lord, their limited pay is, my lord, they may be treated as skilled labor. A similar matter pending before this honorable court in WPC 3410/2019.
Have you enclosed the order?
I hope.
Has the order been enclosed?
No. Let me take up the matter along with the,
When is it fixed?
my lord. Before
Yeah.
once.
There was
I'll need to take instructions on that. I'm not sure if it's a similar matter. Because there was one matter where judgment is reserved. So if it is the same matter, then perhaps I need to check your lordship.
You heard learned counsel from party. Yes,
I am for respond numbers 3 and 4.
3 and 4. 1 and 2, Mr.
One I have to.
One, Mr. Bharat. And 5 and 6,
Your lordship, both the organizations have their separate standing counsel.
who are these?
Mr. D. Nath appears for APGCL, your lordship, and Mr. S. Kotoki appears for AEGCL.
Mr. D. Nath for respondent 5, Mr. S. Respondent 6. Since the councils have represented the extra copy. Please accordingly after the is submitted that a similar matter pending to the court and in prayer date to the court is both the matters together. With this matter being listed along with WPC
3410
3410.
BPW.
Perhaps the names of the other standing councils will have to be shown.
They will be served copy.
Very good.
This is primarily against APTC.
No, they are employees of all the three organizations. No, the
Only-
statement made is that petitioners are presently working as so-and-so under the three successor companies. So I assume that some of them at least are in the other companies.
Names of
Maybe the lordship. Also, this matter has a checkered history because the petitioners were appointed as LDA cum typist and peon in the advisory council of the welfare of civil tribe. Subsequently, your lordship, their appointment has been confirmed. If your lordship directly takes the order of the single judge at page 38, your lordship. My grievance at this moment is I've not been paid the great pay, and I've been paid only fixed salary, which is 15,308 rupees. Instead of there being an order of this court, which has been again upheld by the division bench, to pay me the scale of pay under the ROP rules 2010.
you'll issue notice.
Yes, very good.
Or your appeal.
I'm taking it.
All the responsibility.
And Lord, I will.
Maybe they're not going home. Still after
1 and 2, my lord, I will appear.
1 and 2, who's for 3?
3 is my lord A. Sharma, Anshuman Sharma. I think
Right, for the time being you appear.
my lord, he's a standing counsel. There will be conflict.
He is not here. Have you served copies?
No, your lord.
1 and
Primarily,
Mr.
we are-
Rathod, and 3 submitted that Mr. A. Sharma, the standing counsel, the petitioner will enter extra copies of the served along with a copy of the order on Mr. A. Sharma.
Obliged.
Enabling him to be by the
The petitioner was the driver under ASTC. He retired. After his retirement, by Annexure 12, 1, page 12, Annexure 1, page 12 and 13. The respondent have settled his CPF account and the statement is given at page 13. And thereafter, by Annexure 2 and 3, page 15 and 16. He was allowed to receive unutilized leave salary for 277 days, showing an amount of rupees 3,83,728. and gratuity amount of rupees 7,29,132. But after sanctioning the amount, he has not paid. That is why he has preferred this petition. So direction may be given to release his payment.
Take instruction of the return of profit. Seek for my appeal note.
That's for number 225, Lordship.
That's found as 5. Hard hold. Now who's for transport? Government advocate,
No, Lordship, in for transport.
commissioner and secretary. You can
MD
appeal.
Bora, MD Bora, my lord.
MD Bora. She's the standing counsel for transport.
Yes, Lordship.
Right.
But maybe copy was not submitted. Maybe it's not shown the copy.
However, although number 1 is represented by it appears that treated as it may, the petition council takes steps to serve copies of MS MD Bora standing counsel. Let the matter be listed after the returnable date. The respondents are at liberty to complete their practice and find necessary evidence. Please serve copies on respondent 1 standing counsel.
May I please, Lord?
Yeah.
My lord, in this case, my lord, petitioner is a teacher, my lord. His service was provincialized, my lord, from the year 2013, my lord. And after provincialization, his monthly NPS subscription was deducted from his salary and deposited in his PAN, my lord. My lord, but after perusal of his PAN, my lord, it shows that there is no transaction of NPS transactor prior to 2018, my lord. Your lordship will find one communication, my lord. Page 36, my lord. Page 36.
Yes.
Yes, my lord. Now, as per page 36, my lord, his NPS transaction was lying in his inactive plan, my lord, which is required to be transferred in his active plan, my lord. Hence, he is going to retire from service in the month of April 2025, my lord. Serial number 2, my lord, name of the petitioner, my lord.
Yes, Mr. Portugal.
I appear for the respondent 1, 2, and 3.
You have to infuse pran into the pran.
Yes. So my lord, here lordship will find, my lord, there is a separate agency, the respondent number 5. Perhaps, my lord, the system is operated by respondent number 5. Lordship may be pleased to issue notice at this stage, my lord. Only 1, 2, and 3.
Public. Public.
Here petitioner is, my lord, agreed by one communication. That is, my lord, annexed
17 at page 75. By which melody actually when the petitioner initially was appointed as a non-sanctioned post. I was a process of a regular selection, advertisement selection, everything was there. And subsequently her service was regularized in pursuit of a OM that was published in 2004. Regarding government has taken an initiative to regularize the non-sanctioned lecturers against the second sanctioned post in phase manner according to seniority. And when this her seniority arrived in 2013, as per her seniority list in position in 2201, her service was regularized on 12 2013, which is annexed 8 at page 49, with a condition that she has to acquire net slate or PhD within 2 years. And accordingly, the petitioner has obtained her PhD in 2018. And when that was submitted and claimed for the regular UGC pay scale, there are a lot of queries they made regarding my PhD, whether I have obtained leave, then the migration and everything. And everything was met up. Then the director office come another with the issue that as the direction was to obtain 2 years, within 2 years the degree, and I have obtained in 5 years. So this is not valid, and how I am continuing in this service in spite of the violation of the condition of the regulation. But facts remains that the same college, the another lecturer who was in position number 200, just ahead of 1 number ahead of me, she obtained the same condition, but she was not allowed to obtain PhD, only net or slate. But she obtained PhD after 8 years. Her service was regularized and all benefit of UCI has been given. But in my case, pilot, this is raising objection. So I agreed with this pilot. I played, and this annexer by the 17, they are now suing that how I am continuing. So I apprehended pilot. They may discover my service also. So I will be protection. Then let the notice may go.
Page number?
Page
75,
number
Lordship.
75. And they have given the advanced fixed revised pay scale also, fixed pay scale. And I am enjoying everything. But when the this pay scale will come a question, then they raise the issue.
Yes, anything to
Lordship, it is very clear, Lordship. It was her appointment condition, Lordship, which she has violated, Lordship.
It is not clear, but the similarly situated other
Lordship,
conditions they have not considered.
You did not clear the
No,
net slate.
Lordship.
Not yet.
Why not?
Did you clear the net slate?
I obtained my PhD as per the condition.
You obtained?
Yes. This is obtained as for following all the procedural PhD, the coursework and everything I have did.
So within 2 years?
No, this is within 5. PhD not possible within 2 years,
No, Lordship.
PhD cannot be.
She was supposed to obtain it.
The other candidate, she obtained PhD after 8 years. And her
Lordship,
service is
if
given all
someone is
benefits.
given that
No,
benefit.
is it net slate or is it net slate PhD within 2 years?
PhD also might consider because
In 2 years?
Yes,
Lordship. Not,
if the done it is by through a proper course
Lord,
work
it is
done.
one of the three, Lordship. Net slate or PhD.
What is the difference?
Difference is nothing, my lord. Slate and net is only two qualifying examination that is held by the UGC in every 6 months. And the
Qualifying for what?
My lord,
Qualifying for what?
for appointment as a lecturer in college.
Okay.
Yeah. But the UGC has given an exemption that those who have obtained the PhD after following the all due course of course, that is after entrance, then coursework, then viva, everything, then their PhD will be considered. So this was done as per all the provisions. There was no raise any objection to everything.
Now that she has got her PhD, then what?
But Lordship,
That's why I
after
have
5 years, Lordship. In the year 2018, Lordship, not within 2 years, Lordship.
2 years, which university grants PhD in 2 years?
No university, not
You
possible.
tell us, you show us the list of universities.
Lordship, I'll be filing an affidavit, Lordship.
And you do.
Yes.
Hard learner council. Issue notice returnable 4 weeks at the due comment.
1, 2, and 3, Lordship. 1, 2, and 3.
1, 2, and 3. Steps on respondent for reply by equal court and register meeting within 1 week. Meanwhile, no coercive action be initiated against the petitioner pursuant to the communication. What is the date of the letter?
This is my
6
sixth
three,
bottom of the
24, Lordship. 6/3/24.
2024.
2024. by the deputy director hired the principal and the college. EO Sena dismissed from the till the next letter.
Master. And my lord, there may not be any bar to consider because the other candidates consider.
There may be a bar for. Sorry, what is your submitted?
My lord, there should not be any bar, my lord, to consider because the other similarly considered,
Tendency of the written
already been
will not be
considered.
a bar, considering the. And be listed again on
I have annexed the document also, man. Next 18.
on 19th of June.
Highly obliged. Master.
Yes.
Please, your lordship, this is a common grievance with regard to the ROP rules. My lord has passed a similar order, my lord. It was with regard to my lord grievances with regard to refixation of salary on the basis of the ROP rules, my lord. My lord, on the similarly situated repetition came up before this lordship. My lord has also passed one order and similarly situated on page number 65. my lord. And there were other repetitions also that has been also disposed of on the same line, my lord. 65, my lord. My lord's order is at page 65 and the other repetition.
You want a similar order?
My lord.
Where is the, or do you have a copy of the order of WPC 1806?
My lord. Presently, my lord, I don't have. I have annexed. My lord, I have annexed.
You have any?
My lord. 1806 at page 46, my lord. Page 40.
Yes,
The
Mr. Bora.
Annexure 3 is the main page 40. Annexure 3, page 40 is the first case. Then the after is subsequent, my lord.
My lord, we have filed a affidavit, my lord.
Where, here?
Yes, my lord.
I have annexed all the orders, my lord.
What is your stand here?
Page 75 to 78, my lord. There is a communication by the office of the AD at page 79, my lord.
AD?
Yes, my lord.
Respect of someone else.
Yes, my lord, because on earlier occasion, another petitioner, my lord, obtained a order from this honorable court, my lord, wherein, my lord, it has been held that, my lord, the ROP, my lord, that is applicable to the persons who have joined that before implementation.
Only order, only direction is to revisit and examine.
Yes, my lord, that can be done, my lord.
We are passing similar order there in page 64. 65.
65.
65.
Obliged, my lord.
Obliged, my lord.
Yes. It's this week. You're there? No one has appeared. None has appeared. You're listing it next week.
My lord, my learned friend, complete first, my lord. Already my.
On Lordship, on the last occasion, we had pointed out that since these practitioners were never regularized with government approval or there's no confirmation of their service, Lordship, therefore they will not be entitled to pension.
Was it 13 part?
Yes, sir.
You'll have to refresh our mind. Can we keep it for a hearing date?
Lordship.
Keep it for a hearing date. Have it on a 5th of June.
5th of June, my lord, but I have got many cases fixed, my lord.
12.
12. Of like first.
12th of June. For
Another, my lord,
hearing.
take, my lord, maybe take with, my lord, I will keep number.
You first get the matter listed. Then we can
Already
take.
notice is issued in that case.
You have to get the matter listed and then we can pass an order. Where do we pass the order?
Yeah.
On a mention memo. You want the matter
No,
to be.
I am praying, my lord, and one matter is, my lord, fixed today, my lord, item number 23. This is
Listed today.
today, my lord.
Okay.
But I am praying, my lord, another matter, my lord, may be listed along with those matter, my lord.
You, then another matter you listed.
Yes, my lord.
Then we can pass an order.
My lord. Oblige.
All the matters. Like it. On 12.
Well, of this matter, lawsuit has also passed an earlier order. And this matter actually has become infractious because the challenge made in the writ petition were in respect of an
Nobody here. There's nobody for the petitioner.
lawsuit.
None appears for the writ petitioner. Mr. P.K. Chaudhary appears for the respondent. And to be listed next week.
Lawsuit.
May I please allow?
Yes.
Last of Labor Department was included as a party. They have not filed any affidavits.
We have received the instruction.
Throw it to your feet.
Lordship, let them file an affidavit that is.
They are saying they are not concerned with your issue. They've given you the.
Lordship may take it after some time, my senior will attend.
Matter be listed next week. Yeah, I think so.
Mayor Pilgrims. Well, matter pertains to my lord, non-payment of area salary during my suspension period, my lord. From 12/12/2017 to 29/8/2019, my lord. They have filed an affidavit, my lord. They have took an extent that there is a criminal case pending against me, my lord. In their paragraph 10 of their affidavit, my lord. In the meantime, my lord, during pendency of the case, my lord, my criminal case has been closed, my lord. I have acquitted, my lord. I have filed an additional affidavit to the effect, my lord. Page 73.
What is the stand of the department?
Department, my lord, in paragraph 10, my lord. Their affidavit, page number 32, running page number. In the event of conviction by court, that shall be an act of misconduct on the part of the petitioner as per rule. Is there read with item number 29 of the schedule 2 of CDA rules for taking necessary action by ONGC against the petitioner as per law. Therefore, pending finalization of the criminal case, question as to whether the period of suspension to be treated as on duty or not on duty cannot be considered. As such,
No, after your suspension,
Yes,
was there any departmental proceeding?
no, my lord. No proceeding.
Nothing.
No
You
proceeding.
just kept on suspension.
Yes.
Why?
My lord, it is under deemed suspension. He was under deemed suspension. Therefore, my lord, for the period,
Under what provision?
my lord, my lord, page 36, my lord, of ONGC Conduct and Discipline Rule 1994, my lord. Page 36, suspension, 33, A, my lord.
Artistic of what?
My lord, of our affidavit, running page, my lord, of our affidavit, my lord.
Your affidavit.
Running page 36, of the compilation. An independent suspension order was, my lord, revoked, my lord. They filed one writ petition earlier.
Then extent.
My lord,
If it is revoked, you have to decide what is to be done.
yes, my lord. And for that, my lord, so for the now, in view of my lord, acquittal from the criminal case, my lord, yes, my lord, he is entitled for the remaining, for the balance subsistence allowance. For that period, we already paid 50%, my lord. Now, whatever, my lord, that payment is to be made, keeping that period as on duty, my lord, that will consider, my lord. So for payment for that period, some time may be granted, my lord.
Heard done a council for the market.
Acquittal release. Acquittal.
It won't release of its subsistence allowance. Well,
Area suspense substance.
arrears subsistence. Well, on regularization of period of its suspension.
For the period, my lord, 30/11.
For the period
30/11/2017 to
2011-2072.
to 38/2019, my lord.
Yeah. Pursuant to a fire report. He was arrested.
He was there. Yes. Arranged.
Fire report. Was taken into custody. Subsequently, was released on bail. And the criminal proceeding was initiated. During the entire period, the petitioner was kept under suspension. Initially, his subsistence allowance was not released subsequently to release certain areas were still payable. The criminal case ultimately culminated in acquittal by order dated 18/2023 passed in DRC number 971 of 2020 under section 1273 by the court of SCGMS. Submitted that since the criminal cases that resulted in an acquittal and no disciplinary proceeding has been initiated against the defendant, his claim for arrear subsistence allowance and claim for regularization of the period under suspension is required to be appropriate orders are required to be passed by the ONGC. Mr. D.K. Das, understanding of the hearing, submits a review of the acquittal. The determination will be tried by order dated the last day by the court of LPA. The petitioner is received service his period of service under suspension. His period under suspension, the effect from 2022 is required to be regularized.
As on duty,
Regularize the service as on duty. The learner standing counsel submits that the ONGC is this issue is under active consideration.
Yes.
The ONGC at the appropriate level and appropriate orders are likely to be passed. Taking into consideration also the ONGC authority to pass appropriate orders for regularizing the service for the period under suspension, period on duty, and further release for area salary / subsistence allowance. The entire exercise can begin completed within a period of 60 days.
Some more time,
90 days.
But
Why 90?
but I will
90
inform
from the date of receipt certified. Disposed of.
Matlab that salary would may not be there, matlab the
If
area subsistence allowance.
If any,
Yes, obliged.
areas of,
Yes, ma'am, that would be better.
there is no salary.
No, matlab, he has received.
Area subsidy.
Mal, obliged.
May I please your lordship? My lord, pursuant to your lordship order dated 17/5/23. Kindly take up the affidavit I have filed, my lord. An additional affidavit filed on 21/12/23.
First, tell us what is your prayer.
My lord, my lord, my prayer was that I, being the second wife and the one children, my lord, was not given the family pension of the deceased.
You're not entitled to as a second wife.
My lord, it is entitled, my lord.
You're okay.
And some order to this effect is also passed, my lord.
And the Mohammedan law.
Yes. So, my lord, pursuant to your lordship's order, my lord, because they have taken by misleading the authorities and filing wrong documents, my lord, and keeping me under the understanding that I am getting it, my lord. They have filed the petitions and they have processed everything, my lord. Till then, your lordship has passed the order.
But under the rule, only one eldest of the surviving widow is to be paid.
Yes, my lord, she is to distribute, my lord. Your lordship is correct, as per the division bench judgment. Your lordship is correct, my lord. But what happened in this matter? He has already taken the entire money by misleading me, keeping me in understanding that I will get my share.
they have submitted documents excluding me and my children, including someone who is not even entitled, my lord, the brother of the deceased, my lord. They have obtained some amount, my lord. They have already misused, my lord. They have not done it, my lord. That's why after a long time I have come to your lordship, when I have understood that I am being cheated and being deprived, my lord. Then I have come to your lordship, my lord. Then your lordship was pleased to file direct me to file an application under 510 of that clause of that, my lord, the notification in this regard, my lord. After being filed, my lord, the respondent seeks the commandant of Karimganj, my lord, Teraligun, agreed to pay and got all the documents collected from both the sides, perhaps had heard all the sides. But what happened, my lord? Till then, some amount is taken by them, my lord, around 18 lakhs, my lord. They have already taken and have not given me in a single rupee. Very badly cheated. I have details given, my lord, how I am cheated, how I am deprived, my lord. I was kept in an understanding after 2 years of death of my husband with a very good behavior, extremely good behavior. With them, I was living with them. But they have took my signature on many documents saying that they are doing it.
Represents the other first wife.
First wife.
Why have you not shared? What is your name?
I'm 11 and 12, my lord.
11, 12.
11, 12 is my son.
11 is, you are 11 and
11.
12 is your son.
Yes.
And 13? Who is 13?
13.
Huh?
Brother.
He has taken the amount, my lord, also.
Brother has also come.
Yes.
For pension.
Yes.
How is he eligible?
No.
Already received, my lord.
I already filed affidavit.
Stating what?
I am the younger brother.
How are you eligible? Who has given you that
I
pension?
don't know. As a member of the joint family, my father included my name in next of kin certificate.
Next of kin of your brother. Yes, Mr. Dhor, you have created a mess, so clear it up. Where is your affidavit?
My lord, here is the thing. First, the petitioners established that she is the second wife. We say that, my lord, in our affidavit, there is only if you go by the record, respondent number 11 is, my lord, is the recorded wife in the service sheet. So, obviously, we'll give pension to her. Now, she is a stranger to us.
No, he says even 13 has been given pension.
My lord, that is their submission, my lord. We don't know. We gave it to 11.
Next of kin certificate kindly be seen, my lord.
My lord, now this is these dispute has to go to civil court, my lord. They have to settle it.
PPO is in whose name?
My lord.
PPO is in whose name?
PPO, my lord. PPO, my
Lordship, his service, his date of joining in the service was 5th July 2007. So definitely will come under the purview of NPS.
Yes, they are saying they have received the money. What money have they received? What money?
My lord, we just said that regarding whose name is there in the service record, my lord. That is the name of the first wife.
My lord,
respondent number 11, my lord.
My lord, kindly turn to the paragraph 6 of the affidavit filed by the first wife, my lord. Kindly. This will disclose to your lordship. Paragraph 6 of the affidavit filed by first wife Julfa Begum Chaudhary. She is saying that she do not know anything about all this payment and all these things. Even the ATM is taken away, my lord.
Your affidavit does not disclose the amount is 40 or any amount.
My lord, we said that
Affidavit is
in para 9, my lord.
Is it affidavit of
Respondent number 6, my lord. Respondent number 6.
Yes, para 9.
Para 9, my lord. Page number 59. That with regard to statement made in paragraph 39 to 26 of the writ petition, the answer department offers, but however, it is a fact that respondent number 11, that is my lord, the first wife, Julfa Begum Chaudhary, whose name is recorded in the deceased service sheet as wife of the Constable Abdul, is entitled to the family pension. The writ petitioner, my lord, is stranger to us, my lord. We don't know. There may be a marriage, my lord, but when a person in service, my lord, he gets married to a second woman, my lord, he has to bring it that on record, my lord.
My lord, kindly
Unless that is, my lord, these are disputed question of facts.
My lord, kindly turn to paragraph
Their
6 of,
entitlement, my lord, has to be passed, tried in a civil suit.
when nobody is disputing that I am the second wife and the children, nobody is disputed, already everybody.
We are disputing, my lord. We said we don't know.
My lord,
I raise it, my lord. Para 9.
So even if you are the second wife, your claim as per the rules, only the pension is to be paid to the eldest surviving wife.
correct, my lord.
Ah.
But what happened, my lord? I have,
If the eldest surviving wife is not distributed it,
yes, my
then
then comes, my lord. But already it is already happened, my lord. Even I was kept, my lord. I have details. I have elaborated in my petition how I was deceived, kept, and deprived, my lord, willfully, deliberately.
yeah, you
How
file
wrong.
your complaint, you go to the, you file an FIR, who's stopping you?
No, that's, my lord, the criminal part, my lord. That's criminal part. Your lordship is correct, my lord. But kindly, my lord, turn to paragraph page 3 of the affidavit filed by the first wife, my lord. Kindly have a look.
Why? What is there?
Paragraph 6 of page 3, my lord. What is happening in this matter, kind lord, your lordship will understand, my lord. You'll find, my lord.
That is.
My lord, paragraph 6, my lord.
Respondent 11.
Yes, my lord.
Here.
Filed by respondent number 11 and 12 jointly, my lord. Kindly paragraph 6 of page 3, my lord. That the deponent states that after the death of the husband of the deponent was totally confined herself within 4 walls of the house to perform iddah period. No documentary works was done after the discussion with deponent. The deponent was totally guided by the in-law, especially father-in-law. The deponent was told to put signatures on some papers. Although account opened in the deponent's name, however, the account was not operated by her. The ATM is not under the possession of the deponent. The deponent has not withdrawn and spent money. The deponent is staying in a jointly family, being so and so. The family is guided by the father. And all, my lord, she is not even aware of about that he has taken the money, my lord. Now, my
the
lord.
department responsible for that?
Yes, my lord. So, my lord, now kindly, my lord.
What, on what basis are you claiming you're the wife?
My lord, yes, my lord. I have annexed, my lord, some documents, my lord, in my repetition. That is a page, my lord. My lord, a page, my lord, 24 of the repetition, my lord. That is my, my lord, Aadhaar card before my marriage, my lord. And then, my lord, this is electoral law of 2021, my lord, page 25, my lord.
These are matters of evidence. You go to civil court. That is
My lord, my lord, nobody is disputing that I am second wife. Already they have admitted through filing affidavit, my lord.
No, who, they are not even recognizing your presence.
No, my lord, they have filed the affidavit, all the way. Nobody is saying that I am not second wife or not the children, my lord. It is, this dispute is already over, my lord.
You know, there is a categorical agreement in this affidavit, you see.
My lord, there are affidavits filed by private respondents, my lord. Nobody is disputed, my lord.
You see para 4 of the affidavit of the department.
My lord, the main person is the private respondent, my second wife, first wife.
Go and file a civil suit. Who's stopping you?
My lord, they are not disputing before your lordship that I am the second
We are
wife.
not here to issue writ to private respondent. Why should we? You go and file you get an order from the civil court.
My lord, it's
a matter of evidence.
Perhaps they are the persons to say whether I am the second wife or not, my lord.
Maybe they are then. You get their affidavit does not disclose it.
No, they are not disputing the second wife.
They are not disputing, but they are not admitting. They are not disputing, but they are not admitting.
Impliedly admitting, my lord, because they have not disputed that I am not the second wife or not the
You
second
want a dismissal with cost or you're withdrawing?
My lord?
You'll dismiss it right away. No merit.
My lord,
read para 4 of the government affidavit.
Categorical.
Para 4.
My lord, let me note one thing, my lord. Let it be after 2-3 days. I will, before your lordship, all the case law regarding this, your lordship can decide it under it, my lord. I'll bring all the records, all the judgments before your lordship.
What is
Let
your
it be listed
prayer?
after 2-3-4 days. my lord.
What is your prayer? Your prayer is to issue a direction to the respondent.
Yes, my lord.
Before that, you have to satisfy you the second wife.
Yes, my lord. I'll satisfy
On
your
what-
lordship.
On
I'll
what basis?
satisfy your lordship. Today I have not come of the case laws, my lord. I'll come before your lordship. With case law, I'll satisfy your lordship, my lord.
Withdraw this writ petition and file afresh if you want.
My lord, give me only 2-3 days. I will satisfy your lordship, my lord. My lord, already many years has gone. I am not getting a single penny, my lord. And the children, my lord,
You
not
are
getting.
not getting a penny because you have not come before the court with proper documents to get an order. What is the point in lingering this matter?
My lord,
Are you going to create documents?
My lord, my lord, I have annexed, my lord. My lord, kindly see the, my lord.
All right, list on 21st. 21st. May.
If I go to again civil suit, my lord, it will take another decades, my lord, to get it decided, my lord. And the children is not getting money for
No,
last
because
many
the
years.
civil court will take decades. Are we to assume jurisdiction of the civil court?
Your lordship has the power, my lord, to decide.
We have the power, but we may not like to exercise it because you don't have any document.
Yes, my lord, I'll put, my lord. Yes, that's my lord. 21st, my lord.
21st, yes, no letter.
Okay,
It will be listed on 21st.
okay.
Attempt will be made to dispose of the writ petition on that date. Mr. R. for respondent. Mr. R.K. Kolita, R. for what department you are?
Seven,
appearing?
My lord, I'm appearing for home, my lord.
For
Home
what
and political.
department? Mr. R.K. Talukdar for accountant general, Mr.
HR Chaudhary,
H.
11 and 12.
Chaudhary for
11 and 12.
11 and.
All right.
S. Talukdar for 13. How can the brother claim pension? Yes,
May I
sir.
please, my lord, can the lordship order dated 12/1.
12/1.
12/1/2024, my lord. Is to file an exhibit, my lord, but every time, my lord.
My lord, affidavit has been sent for vetting. My lord may fix this matter next week. Otherwise, my lord, this matter is very simple. Page 32 and 34. His arrears are due to him. So he has.
Examine and pay.
My lord, that is what. Can verify and whatever is due to him can be released.
My lord, may dispose of with the direction to dispose the matter.
Verify his service record, verify his absence period, and accordingly
The
release
order, even.
32 and 33. my lord.
Contrary, my lord,
Okay.
You were taken into custody. You
no, my lord.
No.
That some matrimonial dispute was, my lord, occurred at that time, my lord.
Then why were you placed under suspension? Unauthorized act. And then proceedings concluded.
Proceeding, my lord, not as per the procedure of law, my lord. Only show cause issues and, my lord,
No further proceeding.
no further proceeding.
Then?
Then, my lord, can you see the page 24, my lord? Page 24, impugned order, the type copy, 25, the original.
My lord, his main grievance is with point number 3. He wants this period to be regularized and accordingly the arrears to be paid.
What is LWP?
Leave without
Leave
pay.
without
pay.
He wants the pay for this period. That is his grievance as far as this writ petition is concerned. And he has
Then
filed.
we need your affidavit.
I'll file it within a week.
Then we need his affidavit because you are questioning this.
Well,
You are not accepting the leave without pay.
No.
Your period has been regularized, but as a period of leave without pay.
My lord. 392 days.
You want it to be treated on duty. You want it to be treated on duty.
On duty.
So we'll have to have our affidavit. Heard Mr. A.J.
A short date.
Nick for the PNRD department submit the affidavit in that. The affidavit has not been filed in a short date. To be listed on 30 May.
May. All right.
30 May.
May I please? My lord, in this case, respondent authority pays for fine for filing additional affidavit, though they have filed already, they have filed an affidavit. That affidavit discloses my case.
No additional affidavit has been filed.
Fine. Lordship can take up the matter, my lord, if the other side agreed, my lord.
Yes.
That instruction is not yet received, Lordship. Otherwise, Lordship may direct the dispose of the writ petition by directing the respondent number 1, the secretary, to verify the record.
I'll show my
Lordship,
lord on the
and
face of
pass
the
the same
record.
order. Reason
My lord,
order.
that admitted the position, my.
Within a time frame, Lordship, otherwise.
On the face of the record, my lord, that in their affidavit filed by the director, my lord.
Show us.
So, my lord,
Page number 43, Lordship. 42 is the.
there are, what happened, my lord, Lordship, may I start, my lord, from my repetition, my lord. An advertisement was published on 28th of December 1996, my lord. Annexure 1, page, my lord, 18, Lordship, kindly see vernacular. This is an advertisement, my lord. In response to that, my lord, petitioner filed her application. Thereafter, call letter was issued, annexure 2, page 19, my lord. Then, my lord, he also furnished the, my lord, requisite money for that, my lord. Thereafter, select list was published. And page 21, annexure 2B, my lord.
Yes.
This is the appointment letter by which, my lord, 3 persons were appointed in the under the DI of school Shivsagar. In, my lord, my school was Amulapatti LP School Shivsagar, my lord. Serial number 2, Momi Gogoi, so and so, Amulapatti LP School Shivsagar. This appointment was issued on 6/12/1999, my lord. Then, my lord, thereafter, she was forwarded for, my lord, undergoing, my lord, teachers training course. Accordingly, she proceeded, and after qualification, my lord, certificate was issued, annexure 4, page 25. Then her service was regularized, page 26.
The government affidavit says your name is not included.
That is what happened in this case, my lord. Thereafter, by her own request, annexure 8, page 30. On her own request, page 30, page 30, Mary. On her own request, Timothy Momi Gogoi, assistant mistress of Amulapatti LP School, under the DI of School of Shivsagar, is hereby transferred in her own grade and scale of pay in Nimunagor Bagicha LP School under DI of School Nazira, Block Elementary Education Officer Nazira, with immediate effect. So this is the reason I am not receiving my salary. Page 21B, my lord, by appointment, 3 persons were appointed. All were getting salary, my lord. Remaining 2 are getting the salary regularly, my lord. After that, my lord, in that block, Nimuna, my lord, Nazira block, there was some irregular appointment, my lord. While conducting inquiry, they examined my case and found that, my lord, I am not in that list, my lord. That is what they have stated in affidavit. Last paragraph, page 43. It is stated that deponent that the name of the petitioner is not included in the government approved list against which the appointment have already. Those who were illegally appointed, my lord, they prepared a list pursuant to an inquiry, and out of that list, an appointment was issued on, my lord, in the year 2021, my lord. I am not in that list, my lord, because I was transferred from Shivsagar to Nazira, my lord. I do not belong to that group, my lord. It's a case of discrimination, my lord. Similarly situated persons, those who are appointed with the petitioner, are receiving salary till date regularly. I also received my salary up to February. My lord, 2012, my lord. Thereafter, because of this inquiry and all that, my lord, my salary is held up. I am working regularly.
Sir, here no, that, I mean, you applied for a transfer, you were transferred.
Yes.
Why your salary should be held up?
Salary is held up. What happened in my lord Nazir? I am appointed in DI of school Shivsagar, my lord. After transfer in Nazira, my lord, what happened in Nazira block? There was irregular appointment, and they considered me in that group without considering the fact that I've been transferred from Shivsagar to Nazira, my lord. That fact was never taken into consideration. And those illegal appointees, they prepared a list and thereafter approved the list by the government, and they were also appointed. I am not illegal appointed. My appointment was made pursuant to selection process. I have annexed everything, my lord.
Yes, Mr.
Lordship, the affidavit filed by the director shows, Lordship, page number 43, paragraph 4. The answering deponent humbly begs to state that the present petition did not receive monthly salary since August 2006 due to shortage of post and budget provisions, as the allotted posts were less than the working teachers in Shivsagar district. So the salary of all the teachers could not be paid. Thereafter, white government later number so and so dated so and so 1528 numbers of supernumerary posts were created and temporary retention and budget allocations in respect of 1476 numbers of posts were recorded out of 1528 by the government for the period from 28 to 2012. White order number so and so dated so and as such 1476 number of supernumerary teaching, including the petitioners, had got their monthly salary up to 2012. That salary was given by creating supernumerary post. The government of Assam in the elementary education department took over the matter of all these illegal and irregular appointment teachers and approved certain numbers of verification for appointment in 2021 by way of cabinet decision in the meeting on so and so. Accordingly, the appointments were made on 31/1/2021 as the approval communicated white government number so and so dated 21/1/2021. It is stated that the deponent that the name of the petitioners not included in the government approval.
That is those who are illegal and irregular, my lord.
Those who
I
were
am not in that list, my lord.
Those who were accommodated now. The reason why the
Accommodation
name
was
of the
made in
petitioner not.
respect of illegal and irregular appointee. I am not belongs to that group, my lord. So, my lord, if secretary of the department consider the my lord case, my lord, he has to consider, my lord, and accept proof whether this.
Consider for what? What is there to be considered? From 2012, we have not received your salary.
They have to consider whether my appointment was made regularly, my lord.
Is the petitioner still working?
Yes, my lord. That I have annexed, my lord.
The salary has not been paid, Lordship.
Salary has not been paid, but what is the?
Page 31 of my writ petition, annexure 9, my lord.
Your affidavit does not disclose that.
That is why, Lordship, we want to file additional
My
affidavit.
lord, this is a case of discrimination, my lord. Similarly situated person who are appointed with me, my lord, they are receiving salary regularly.
You don't receive salary from 2012 when you file a writ petition in 22, alleging discrimination.
But I am working in
And the government has very conveniently not stated whether you are still in service or not in service.
That part is not there in the affidavit, Lordship.
You get this instruction.
Lordship.
Disposal will not help you. Let them get it.
Lordship, allow 3 weeks time.
My lord, while filing the affidavit, my lord, that should make.
Sharma will apprise the court as to whether the petitioner has been in service in which school.
My lord, in my lord 134 number.
Where is it?
My lord, page 31 of my writ petition. 194 number, Nimunagor Bagan LP School.
134 Nimunagor Bagisa LP School. Under the Deputy Inspector of Schools, Nazira, and Block Elementary Education Officer, Nazira.
And my lord,
stop. The respondents will apprise the court as to the status of the employment of the writ petitioner in this same school after February 2012.
Yes.
Then this instruction be placed before the court.
My lord, 3 weeks, Lord.
3 weeks. 2 weeks.
2 weeks, Lord.
My lord, one thing, my lord, page
Yes.
21, my lord, the appointment letter. Those
And
who are
will be
working,
listed on 31st.
Yes.
Yes.
page 21, they also consider, my lord, examine the, my lord, appointment letter, page 21.
Hmm.
Because why necessary, my lord? They have, my lord, identified the illegal and irregular appointees, my lord.
No, we want to find out whether you are employed or not. That information, if it comes, then we'll pass other orders.
No,
Yes.
But in this case, the petitioner was elected by the competent authority member. But
Here in this, your lordship, after the amended writ petition was allowed, we were not supplied extra copies of the amended writ petition, so we have to file an affidavit to the amended writ petition. We have otherwise filed affidavit to the
You have
main
not
writ petition.
given copies.
we have chapter copy.
Only one copy, your lordship.
Third copies, the standing council. What government advocate? Submitted by the government advocate has not been furnished. Sufficient copies of the amended writ petition, enabling them to complete their instructions on time necessary. Petitioner council will ensure supply of amended writ petition within a period of 1 week from today.
During the course of the supply.
Today only, we are giving you 1 week's time, matter being listed on 31st May.
Fine. Obliged, ma'am.
May it please the lordship.
Yes.
My lord, though there are three writ petitions, the point involved is a very short one, my lord. Now, the petitioner before lordship, my lord, he was an executive of the NRL, Numoligo Refinery. Now, there was an allegation of sexual harassment in workplace by an woman employee of the refinery, my lord. Pursuant to that complaint, lordship know nowadays there is a requirement of constituting an ICC in every workplace. Now, while the ICC inquiry was going on, based on a police complaint filed by the respondent, the petitioner was arrested. And he was in jail. My lord, he was arrested on 28/21 and he was released on bail on 26/10/21. During this time, my lord, the ICC inquiry progressed substantially. Thereafter, of course, my lord, I was asked whether I will submit my written statement or not. Also, no, in the meantime, already witnesses were examined. So there are a lot of flaws. Now, secondly, my lord, what had happened, based on the ICC report, a show cause notice was issued to the petitioner. Lordship knows under the Supreme Court has explained the procedure. The ICC report itself is to be construed as a report of the disciplinary inquiry. And the disciplinary proceeding has to start from the stage of serving that second show cause notice. Now, there is no occasion to again issue a show cause notice because this is where the complaint itself is the my lord complaint. Based on that, inquiry is already there. So this is the second flaw. Thirdly, my lord,
This is, I think, a mandate of the CCR.
Yes, not mandate, my lord. Eventually, there is a judgment of the Supreme Court. And in fact, CCS rule has also been amended.
Yes.
I'll just place that amendment, my lord. Lordship will kindly have this. I have brought only the relevant portion because it's a very bad book.
Yes.
Please come to the next page, my lord. Rule 14(2) proviso. Provided that where there is a complaint of sexual harassment in the meaning of Rule 3C of the CCS Conduct Rule 1964, the complaints committee established in each ministry or department or officer for inquiring into such complaint shall be deemed to be the inquiry authority appointed by the disciplinary authority for the purpose of these rules, and the complaint shall hold if separate procedure has not been prescribed for the complaint committee for holding an inquiry into the complaint of sexual harassment. Inquiry as far as practicable in accordance with the provisions laid down in rule. In other words, if a separate rule is not provided, then whatever is provided in CCA classification control appeal rule, that will govern it. Now, my lord, in this case, there are a lot of errors. As a result, I have been prejudiced. From, my lord, 28-21 to 26-10-21, I was in jail. I was released only on 26th. During this time, without any written statement of defense, everything progressed. So my humble submission at this stage is, my lord, this inquiry report, since it contains a lot of flaw, it should go back, my lord. They should do the inquiry once again, and in the meantime, I should be reinstated. And in the meantime, what had happened, I was getting, my lord, subsistence allowance of 50%. So that has been reduced to 25% on the ground that because I have approached the honorable court, so therefore delay is attributable to me. Look, we are not governed by British, my lord. We have a constitution. What is this corporate mentality, my lord? An employee cannot go to court. Can you see that order, my lord? Please have, my lord, WPC 2163 of 23. It is a silence question, huh?
Second.
Sorry, my lord. 8334 of 22. 8334 of 22, page 59. The reason for reducing my subsistence allowance, page 59.
Yes.
May I have your lordship's kind attention to the second subpara? An enquiry officer in the stature of retired judge was appointed in the departmental proceeding against you for bringing reasonable closure to the issue. However, the inquiry proceedings has not progressed due to your non-cooperation, because this inquiry is not even envisaged, my lord. The inquiry proceeding has got further delayed because of the stay order of the High Court. So it is High Court who is to be blamed, my lord. Why High Court has passed this stay order? This is the state of affairs.
Okay, now.
My humble submission is, my lord, this matter should be remanded. They should start from the stage one. That is, there is a complaint.
Now, let us understand.
Yes.
There was this ICC committee.
Yes.
They conducted an inquiry. But you were in.
But I was in jail.
Now, what is this page number 59 that you pointed?
Now, what had happened, my lord? What had happened? Then I filed an appeal saying you can't proceed and all. Then they say appeal will be maintainable only against the final order.
No, this inquiry officer in the stature of a retired judge is in respect.
No, that was in the departmental inquiry which they had again issued a show cause notice. Which we say it's not maintainable. You can't do that.
Separate inquiry.
Separate. So ICC report itself is the inquiry report.
Yeah.
Now, if a lordship would kindly have the judgment, my lord, that will give an clarity on the aspect. Extra from the class. My lord, we kindly have this. Why the appointment of the, my lord, I have not given the whole judgment. Please come to para 44.1.
Medha Kotwal, yes.
Yes. Para 44.1.
There is a subsequent judgment.
Yes.
Subject to correction.
But that dealt with, my lord, whole gamut of issue. In para 87, what all are the procedure to be followed? Everything has been given.
Right. No,
Yes.
there is a subsequent judgment where.
Yes, this is the subsequent judgment, my lord. I brought it. Arun, Aurelino Fernandez. A. Fernandez versus State of Goa. It's a little judgment, 2024 one is.
Judgment.
My lord.
Hima Kohli's judgment.
Yes.
No, that.
Honorable Justice Bopanna and Hima Kohli. Yes. Please come to para 44.1.
No, there is another. Where subsequent correction, I recall that the Supreme Court said that no, you have to have a separate inquiry.
No, that is the Delhi court. Yes, Lordship, there's one more.
Perhaps.
This is one. Yes. This is, yes. There is the Vijay Kumar CVC versus Central University of Kerala.
Justice
Yes.
authored by
This
This is
is,
2020.
no, this is with a different matter. He is talking about cases where the central service rules are applicable, or the CCS is applicable. Here is a case where many organizations, which they have this own standing orders, own appeal and disciplinary rules, they have their own rules. In those cases, what the POSH Act says is that the IC will conduct an inquiry, which is more in the nature of a fact-finding inquiry, Lord. And it's a preliminary report which the IC will give to the authorities either to take action on the recommendation. The authorities cannot sit tight, they have to act on that. And the delinquent also has the opportunity to file an appeal against the IC's the inquiry findings of the IC. Now, once the authority gets the IC report, and if the IC recommends punishment as per the rules, they have to follow their rules and hold the inquiry. That's the second inquiry which they have to hold. So in these are two different sets, because some places they are not, they have their own rules. So
Correct. That is when you want to impose a major penalty.
absolutely, Lordship. Paragraph 12 of the judgment clarifies the entire thing.
But my lord, I do not know. These are three judges judgment.
No, but that is a CCS.
No, Megha Kotwal is a three judges judgment.
Correct. That is in case of where the CCS rules are applicable. But what happens to cases where these are not applicable? And Megha Kotwal, what happened? Initially, the Vishaka case was there. And Supreme Court had given a whole lot of guidelines. Nothing was followed. They had a committee, but
There's no quarrel.
and then Megha Kotwal.
No, my lord, my learned friend is trying to draw a distinction based on CCS and other rules governing the service condition of the PSU.
Absolutely.
My lord, end of the day, my lord, these are all perimeterial. Rule 9 of Assam, Rule 14 of the CCS.
The judgment of the effect.
There's judgment on distinguishing.
Judgment of the effect.
Okay.
That's over and above the ICC. There must be a proper inquiry.
No, my lord, based on 44.31, CCA rule has been amended.
Amended, correct?
What I placed.
That amendment. So I
No,
think
even, my lord, the rules of the NRL is also not in conflict.
So this is also treatment.
They say, my lord, they will apply mutatis mutandis.
see, the strength of the bench is irrelevant for this court.
No, both are three judges, Doctor.
No, my lord, with all respect, I'll submit the strength of the bench is matters. Honorable Supreme Court says if High Court is confronted with a judgment, then High Court should follow larger bench. My lord, that is 1970.
And the other one is also three judges. By the way, both are
77 for SCC, huh?
both are three judges. Both are three judges. So we are on paramount because these are in two different aspects of it, factually. And Megha Kotwal basically led to the enactment of the POSH Act.
Let us see your rules. You have the rules.
I have the rules.
The rules I have also annexed in the petition.
Rules are annexed.
Now, what had happened, my lord, when we filed the appeal, now, if your lordship would like to go toward that aspect, it's okay, my lord. I have a small prayer today.
No, your prayer is simply that because you are in custody,
Yes,
these matters.
I could not make any effective representation. I could not,
No, Lordship, I have no quarrel on that he was in custody. If the Lordship sends it back to the IC also, it is fair enough because it is correct. He was in, I must be fair, Lordship. But the point is to say that, that inquiry, we must have a two-stage inquiry because we are not covered by the CCS. We are covered by
the second stage of inquiry also.
Oh, yes.
You're bound to refer to the ICC committee report.
No, Lordship, because it is as per the rules, even the access.
Then, my lord, it will become a fact-fighting. It will become a preliminary inquiry.
ICC
then the whole purpose of act will be frustrated. It's a parliament act.
The act itself says, Lordship. Act itself says. You have a one more level.
No, my lord, if eventually lordship holds that ICC report can form the basis of a second inquiry, that's an additional safeguard for the employee. That I'm not on that.
Absolutely.
Well, whether that will be the correct position of law, that will have to be decided.
Subject to what the judgment said.
So these two judgments are there, Lordship. This is one.
So, my lord, my prayer would be, I think this matter will require some hearing in that.
Absolutely.
Case. Well, I have a small prayer. I was receiving subsistence allowance which has been reduced. On last occasion, when the matter was listed,
So that
the
can
on-
be done.
that I think, my lord,
That lordship can give,
that will get as per the, my lord.
as per the rules.
Yes.
As per the rules.
At 29/4/24, lordship has already clarified that. Let appropriate instructions be taken on the aforesaid aspect as prima facie subsistence allowance is required to be paid at the prescribed rate, which is not connected to the outcome of any disciplinary proceeding.
Lordship will be as per the rules.
So, my lord, the deduction part has to be stayed, my lord.
Yes, we have no problem.
We fix it for hearing.
Yes, lordship.
It might, it's an important
It's an
question of
important matter because
Heard learned counsel for the Mr. K. N. Chaudhary, senior counsel, assisted by Mr. MS so and Mr. P. Kotoki for the petition. MS M. Hadarikal and senior counsel, assisted by
D. Khan.
D. Khan. And Mr. Bonik also.
I appeared for the lady below as a legal aid counsel in item number 163.
Yes, Bonik.
Oh,
Yes,
এখন দিল্লি হাইকোর্টের মানে সুপ্রিম কোর্টের
Yes,
Yes,
counsel
2020.
appearing for the victim
4 to 6.
of the alleged
426.
incident, which is allegedly attributed to the writ petition. The petitioner is agreed by the fact that the ICC the Internal Complaints Committee they have concluded the inquiry. ICC.
ICC has concluded and given the report.
They have
And given the
concluded
report.
The inquiry and submitted the report. However, during the conduct of the inquiry, the writ petitioner was taken into custody. He therefore submits that his valuable evidence could not be placed before the ICC.
That I could not file my written statement.
Not even file the written statement. And therefore, the ICC report cannot be treated to be valid as per the provision. So, senior counsel referring to Rule 14 of the CCS rules submits that the amended provisos Rule 14(2) provides that where the ICC where provide that for inquiry of complaints into sexual harassment at workplaces, the inquiry conducted by the ICC, as far as practicable, will be treated to the inquiry conducted by an authority appointed by the disciplinary subject to there being no separate procedure prescribed. Submitted that since this is the provision of the rules, if the inquiry ICC committee report is accepted on as it stands today, the petitioner is found to be seriously prejudiced. He therefore submits that the petition be allowed and direction be issued, setting aside the inquiry report and demanding the matter back to the ICC for a fresh inquiry. And the further submission of the petition is that his subsistence allowance which he was receiving has been reduced to
50%.
Reduced to
25%.
25%.
Has been reduced to 25%.
Whether it should go up to 75% after 6 months.
Which is again contrary to the provision of law. MSM Hadarikal and submits that the provisions of the Rule 14(2) of the CCS rules are applicable where there are no separate procedures prescribed. Stop. So far as the ONGC is concerned.
Not ONGC, NRL.
NRL, sorry. There is a separate procedure.
Yes.
Prescribed. Therefore, second inquiry is contemplated. Stop. Learned Senior Counsel has referred to the judgment of the apex court in
Export lot.
that 2020,
2020.
12 SCC 426.
2020, 2020, 12 SCC 426.
Page
Sub-
426.
And again, that it's relied on the judgment of the apex court in Meda Court 1 Lady. We are relying on the other judgment also.
Mala, other judgment is not directly on the point.
I think 24 is good enough for you.
Where, having heard learned counsel to the court, learned senior counsel has fairly submitted that the petitioner is indeed entitled to subsistence allowance at the applicable rates paid. The such circumstances, let the matter be listed for hearing. This is admitted or it's for admission hearing?
It's not admitted. It was for admission.
We'll give it for admission hearing.
Admission hearing.
Admission hearing
Listed
finished.
for admission hearing. On, give us a date.
Sometimes in the June, my lord,
Yes.
after first day.
11th of June?
Yes,
11th of June, Lordship.
11th
yes,
of June.
yes, a Tuesday.
It's a Tuesday.
11th of June is agreed to by the learned counsel parties. Meanwhile, the petitioner will be released, will be granted his subsistence allowance at the rate applicable.
Or lordship may say that for the present 27/9/22 order is stayed. That will naturally entail that consequence.
Yes,
That page 59 order be stayed at WPC
I think that is better.
8334, my lord.
Where is the page number?
Page 59.
And the authorities will endeavor to release the subsistence allowance payable to the petitioner in the order dated
27th of September 22.
27 September 2022. Age 59 and age 10 of the petition shall remain stayed until further order.
Reply.
Obliged.
Please, Lord.
Reply.
May I please with your lordship? Your lordship, my husband rendered his services as temporary government employee lordship. And initially he was engaged as a casual worker lordship on 1/6/1994 lordship. That has been reflected into their annexure lordship. Page number 34 lordship clearly mentioned that he was joined in his services on 1/6/1994. Then thereafter he rendered his services 22 years, 9 months lordship. And in the meantime, lordship, he was appointed as a temporary government employee lordship. That is on 20 annexure 5, page number 41 lordship.
Yes.
On 23rd of December 2009 lordship. And thereafter lordship, he died in the meantime in the year of 2019 lordship. And after death of my husband lordship, I am claiming for granting pensionary benefit lordship. So lordship, I am entitled to get such benefit lordship as per rule 152 lordship. That is lordship, chapter 9 special provision clearly mentioned that lordship, temporary employee entitled to get pensionary benefit lordship. May I read this lordship? 152 rule lordship as per Assam Service Pension Rule 1969 lordship. Temporary employee who retires on superannuation or in discharge on account of retirement or is declared invalid for further service will be eligible for gratuity at the rate of half a month pay for each completed year of service, provided that he had completed not less than 5 years continuous service at the time of retirement, discharge, or invalidation. Then, lordship, one office memorandum has been passed to lordship dated 6 September 2003, lordship, that is still now standard scrutiny of law lordship. It was not challenged by the any authority lordship. This notification has clearly mentioned that your lordship, in continuation of this department OM number so-and-so dated so-and-so, it is reiterated that state OM clearly lays down that the government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefit. The focus is on 20 years of continuous service after rendering 20 years of service. If the government servant is superannuated or incapacitated or dead in not the moot point, any confusion in this regard is against the spirit of OM referred to above. It is therefore clarified that pensionary benefit as contemplated in the above OM shall be admissible to a government servant who died after rendering 20 years of continuous service. Other terms and conditions for eligibility of pension shall remain same as usual law. Therefore, on basis of this lordship, I am claiming for pensionary benefit lordship.
What is the stand of the department?
Not.
Department. They have objected. They have disputed your claim.
Lordship, I am entitled to get such benefit, Lordship. What is the bar, Lordship? Not regularization of services of my husband, Lordship. That is fault of the government, Lordship. The pensionary benefit has been denied merely a ground that my husband's services not regularized. What is the fault of him, Lordship? That during
Can't be regularized now.
yes, Lordship, that is the fault of the government, not the fault of me. Yes, because Lordship, I have duly qualified, Lord.
Unless it is regularized.
Yes.
Can't be granted.
Yes.
Now your husband expired.
Yes.
Working as a temporary employee.
Yes.
Service was not regularized.
So Lordship, 20 years continuous service he has
Maybe,
already.
but in order to run pension, had he been alive, maybe we could have directed to create a supernumerary post and regularize him for the purposes of pension. Now he's expired. How can the direction be given now?
That is losses, Lordship.
Which law?
This notification, Lordship, it was not challenged, but it is standard scrutiny of law, Lordship.
What is
even Lordship, the Supreme Court very much clear, Lordship. That is the judgment is Honorable Supreme Court, Lordship. CBC, Lordship. Number of judgment, Lord.
Yes.
Honorable. One is the Lordship 1996 7 SCC 113 Lordship. Yes, one Hari Katakar versus Union of India 19 September 1994 Lordship. Hearing stated that Lordship the was a permanent government employee Lordship entitled to get pension benefit.
Yes, but the employee was there. Here he's not here, he's expired. The
It is
petitioner
not
has
our
been.
hand, Lord.
Huh?
It's an unfortunate death, Lord.
Unfortunate.
It is not hand of us, Lord. What is the what is the fault of him, Lord? I am entitled to get such benefit, Lord.
This is not a complete judgment, I think. You take out a proper copy of this judgment.
Lordship,
Yes.
the petitioner husband was a master rule worker, my lord.
Hmm.
And till the date of his death, he is receiving the minimum of the pay scale. Lordship, may kindly have a take up my second affidavit in opposition, additional affidavit filed on 28/8/2023. Two affidavit I have filed, my lord. And similar, this is the third round of litigation, in fact, my lord. The earlier dishonorable court wants to dismiss his case and he withdrew his petition to file a fresh. Then similar matter, Lordship, this honorable court has already dealt with. And Annexa 1, page 50, Lordship, it is a October 2019 MR Worker Bill, my lord. Lordship, page 50, Lordship. Lordship, page 50, my lord may kindly have a look. Annex. Everything has been given. The area is also been given. The area which was due to his petitioner husband, my lord. Page 50. It is the October master worker bills. He was getting 19,023, which is the minimum of the pay scale, my lord.
No, he's not denying that. He's asking for regularization.
Regulation, how MR worker, my lord, was never regularized. Till his date of death, he was working as a MR worker. This is the October bill, and the petitioner husband died in harness on
Have you,
1411.
Mr. Counsel for the petitioner, have you, what is the law is regarding MR workers is the Zupen Das?
Yes, my lord.
How can he amount worker lordship? Then why this order has been passed lordship?
Which order?
Whether this order has been revoked or
Which order?
set aside lordship,
Which
temporary appointment lordship.
Which order?
Appointed as temporary, been appointed. 23rd of December 2009 lordship.
Page number.
Page number 15 lordship. My read petition lord.
15. Following master roll worker. Page number 15.
Yes, lordship. That is lordship office order. Master rule worker train crows who's under the directorate are hereby temporarily being appointed as law school.
No, but as master roll.
As master role, he never joined the post of law scholar. In
Not
fact,
same,
I have
same
given.
category I rendered my services, not providing the appropriate allowances to me does not
You were
mean lordship.
appointed as a master roll worker. Now the Upenda's judgment of the division bench says that they are not entitled to regularize, but they are entitled to fixed pay and.
The division bench, Upenda's judgment lordship passed in the year of 2017 lordship, but lordship, this order is in the year of 2009, appointed as scheduled worker.
Which order? 2009.
2009, 23rd December lordship.
You are appointed as a master roll trained crew.
True lord, as lord scholar.
No, where?
On temporary basis, lord.
Appointed as
Director hereby temporarily appointed as law score and post and the place of tone below again.
What is the law score?
It's a grade 4 post, my lord, law scholar.
Yes, yes. If
But
it
he
is
never
grade four,
joined.
then
In
why not?
our affidavit, page 28, paragraph 6, we have replied to that lordship. Paragraph
Did
6.
not join.
He did not join.
Lordship, authority directed me to join in the particular post, particular place. I have joined. Authority has never granted sufficient allowance to me. What is the bar lordship? Your lordship
Where
can
is your
determine lordship.
Where is your
Being a
joining
post
letter?
employee lordship,
Where
can
is your joining letter? Where is your joining letter? Where is your joining letter?
Yes, I approach after receiving this order. I approach before the authority lordship.
To do what? To join in the post.
Yes.
For joining, you have to submit a joining letter. Do you have the joining letter? Is it enclosed here?
In my description, it was not a fixed lordship, but it will be available with me, Lord.
Get that
After
joining
searching, I will place the same.
Lordship, till October 19, he was receiving minimum of the pay scale, my lord. Lordship may dispose of the matter in the similar line.
If you have joined, you bring that joining letter.
Lordship will find and
Bring it.
place the same. Lord.
Yes, bring it. How much time do you require? Next week? Next week?
2 weeks.
No, next week. Get it next week?
Lord.
Please. On 24th. Sorry. 24th. 24th of May. Enabling the learned counsel for the petitioner to place on record the joining letter of the writ petitioner joining in the post of law scholar pursuant to the appointment order dated
2009, Lordship.
23rd of December.
23rd, 12, 2009.
23/12/2009.
9.
Mr. S.K. Medi, Ms. MS MD Bora for Transport Department, S.K. Medi for Accountant General, Mr. R. Pujari for Finance.
I'm aware.
Lordship, may please your lordship, on the last occasion, given the lordship will kindly peruse the order dated 18/12/2023.
Lordship, I have an instruction. Lordship, there are 13 writ petitioners. Out of these 13 writ petitioners, 2 writ petitioner, 11 writ petitioners has been attached with the amalgam. The school of the writ petitioner have been amalgamated with the secondary school, Lordship. Now that process will be taken up by the second director of secondary education. And perhaps on the last occasion,
We have recorded this
And-
statement.
and remaining 2, they have received their
We recorded the statement on 18/12,
lordship.
that
So,
the area salary proposal has been forwarded to secretary.
lordship. Now, lordship, for the secondary education, that instruction is out at, so lordship may fix the matter after.
Your lordship, let him take the.
For the
let him
secondary
make
lordship.
This is an incorrect submission. That submission was made long back, 5 months back. The position is like this, your lordship, on 18/12/2023, they stated categorically that as regards respondent number, petition number 4 and 9,
4 and 9.
the salary has been forwarded. So what is the status? They don't
No,
have any instruction on that.
That has been dispersed. That instruction I have placed
No,
before the lordship.
no,
now.
no, he has not given me a copy.
In respect of petition number 4 and 9, they have already received.
That may be kept as a part of record. I'll take a copy from him.
4 and 9, they received already.
Who received?
Writ petitioners, those who were under elementary education. And the school of the remaining writ petitioner has been amalgamated with the secondary. Now the director of
What is the status of the
2 writ petitioners they have received.
2 writ?
Lordship.
That is petition number 4 and
Petition number 4 and 9.
It is submitted by the elementary education that the petitioners 4 and 9
Lordship.
already received their salaries. And the rest of the writ petitioners' proposal are required to be forwarded by the Department of Secondary Education, in as much as their schools have been amalgamated with
the secondary school.
With the schools in which the other writ petitioners are working have been amalgamated with secondary education in secondary schools. So, who's for the secondary department?
Lordship, Mr. I will convey. Lordship may record the name of
The
Mr. N. Thakur.
secondary education department will apprise the court as to the release of the salaries of the other writ petitioners. Let the matter be listed after 2 weeks.
Lordship.
Mr. P. Sharma appears to be accountant general. A copy of the instructions furnished by the Standing Council Elementary Education is kept as a part of the report.
Your lordship, may I pay for a date in that case after 2 weeks?
After 2 weeks, it's on 31st.
Deeply obliged, your lordship.
Yes.
May I pray your lordship? In the meantime, pursuant to your lordship's last order, Finance Department has filed their affidavit admitting our statement, the record. Only thing is they're saying that according to ROP 2017, we issued the notification and it is the administrative department, that is secondary education department, they are to implement. And so far in the given section circumstances, our prayer is very simple. In 4-5 districts, already grade pay as sought by the petitioner before your lordship are paid. We should also get with some areas. So, lordship, petitioners before your lordship, initially they were the senior madrasa teachers. Their services were regularized in 2013, 1/1/2013. So, that starts from Annexure 1, page 50. All the teachers, there's service regulation order, I have annexed in the restriction. That Lordship, now kindly come to page 72, Annexure 12 of the writ petition. This report of the anomaly committee. Now, what happened, my lord? When our services were regularized, we were having the basic qualification only without having the training part, training qualification. We are not delayed, whatever it means. So, kindly have a look at page 73. Recommendation on crucial issues, education department. Now, that concept of that senior madrasa gone. Now we are under secondary education department, ME school. Or some of our school services already amalgamated with high school or higher secondary also. So anomaly in grade pay of graduate teacher. Now, Lordship have a look. Before that, kindly come to page 16 of our writ petition. Out of 25 petitioners before your Lordship, for convenience sake, it is stated writ petitioner number 1 to 12 are trained graduate teacher, and writ petition number 13 to 23 are FM and Hindi trained graduate teacher, whereas writ petitioner number 24 and 25 are trained undergraduate teacher. These are the three categories. And thereafter, kindly have a look to page 41 of the writ petition. Yes, I have given the list. When we acquired the qualification and from when we are entitled to grade pay. Records are also, documents are also annexed. Department can verify after getting your lordship's order and to pay. This is very vital. Page 41 onwards, I have given that list in para 27 of the writ petition. Now, kindly come to page 3, page 73. The Finance Proof Department has referred the matter relating to pay fixation of teachers of lower primary and upper. I am reading from Anomaly Commission's report, my lord, page 73.
Yes.
Page 73. It starts from page 72. Yes. Lordship got it?
Is there an order rejecting your claims?
No, no. We have also filed representation. Some other district, they have paid, those orders are annexed here in the writ petition itself. For
Now,
district
what
already
is
paid.
this, what is the stand of the finance department here?
Finance department says that they have filed, kindly have a look to their affidavit, lordship. My learned friend has filed. Lordships, I have with this finance department, kindly come to para 4 of their affidavit. First. Page 218, Lordship. Yes. In the director's affidavit, there is nothing. We have also replied. Nothing to object. Yes.
Yes.
May I read, Lordship? The answering deponent begs to state that the matter pertains to secondary education department and the finance proof department via government notification dated 4/8/2018. That is annexure 14, page 80. Notified some amendments in the schedule to the Assam Services ROP Rules 2017, published in the extraordinary issue of the Assam Gazette dated 17 March 2017, under the notification number so and so dated so and so, namely under the head education department below the subhead Assam Lawyer School Service, Tracing and Inspection ME, MB Senior Basic School and LP Junior Basic Pre-Primary School. As per this head notification, the 10 graduate teachers are entitled to the grade pay of 8,700, irrespective of arts, science, commerce graduate. And the untrained graduate teacher, including trained undergraduate teacher and untrained undergraduate teacher, are entitled to grade pay of 6,800. Not at any rate 6,200. Presently, we are getting the very minimum. At the entry point in 2013, we got 62. That is we are getting. That is the discrimination. Whereas other districts has already, 4-5 districts has already allowed it. In the kindly below, it is stated that finance department only issues notification as per provisions of ROP. It is up to the concerned administrative department, that is secondary education department, to take action as per notifications as laid down in ROP rules issued by the finance department from time to time. Then kindly have a look to the next page, page 220, Lordship, paragraph 7.
Yes, carry on.
Yes. As regards to the statement made in paragraph 16 of the resolution, the answering deponent begs to state that the report of the anomaly committee 2007 at 2.61 reads as under. The finance board department has referred the matter relating to pay fixation of teachers of lower primary and upper primary school to anomaly committee. In this connection, the committee examined the recommendations of 7th pay and productivity pay commission contained in point number 1.63 of chapter 14 of the report, which is quoted below. The commission feels that at the level of LP and MA school, there are no justification for differentiating the qualification of science graduate, vis-a-vis arts graduate, or any other graduate. Accordingly, the commission recommends that the entire graduate teacher in LP and ME school should have the same grade pay of 3,300. It is further recommended that all other teachers who have undergraduate qualifications should be put in the grade pay of 22,500. In the above recommendation, the 7th APCC mentioned that there is no justification for differentiating the qualification of science graduate, vis-a-vis arts graduate, or any other graduate teacher in case of LPME schools. So the commission recommended pay scale to the other 10 graduate teacher at par with the science graduate teacher without discrimination. In case of ME and other upper primary schools, the anomaly committee feels that there should be parity of pay scale amongst all teachers, irrespective of field, arts, science, commerce, etc. Therefore, the anomaly committee.
Yes, Mr. Borpujari, in the affidavit, there seems to be a paragraph which is repeated in every paragraph.
Yes,
in your affidavit?
Yes.
Why?
If my lord comes to page 47 of the writ petition, that is the prayer portion, they are basically claiming benefits under, my lord, two notifications issued by the
You are not disputing that.
No, because notifications are not on challenge. Notifications lays down the parameters under which, my lord, of under what category of teachers, what will be the pay scale, grade pay, that much. Now it is for the administrative department to apply it, that much.
So, what is the administrative department's affidavit?
That is director's affidavit.
Directors.
Director affidavit. Page 180, paragraph 6.
This is silent on what? Enhancement of entitlement of enhanced grade pay.
Enhanced grade pay in respect of madrasa. This
erstwhile madrasa.
Yes, this is.
So what is to be done here? Finance.
Madrasa, my lord, these notifications does not speak of madrasa because they are relying on these notifications. Page 47 of the writ petition, prayers are very specific. Writ in the nature of mandamus to be issued directing the inspector of schools, Borpeta District Circle, Borpeta, to forthwith pass an order granting the petitioners grade pay due to them for the period when they acquired necessary academic and professional training qualification in terms of notification dated 4th August 2018. That is, my lord, Annexure A of my affidavit.
Who is to verify that?
Education department. Education department, yes.
Director.
Yes.
You
Now,
verify,
whether
release the payment.
Lordship, kindly have a look at page 150 of the writ petition.
And the
That's
second
one example I am giving. Other district has already released. We are seeking just parity. Article 14, Lordship. Page 150 of the writ petition. Lordship, that's one order. I have annexed several orders. So what is the reason of withholding our pay, Lordship? Nothing. This is the order of Kamrud district. Same. They have already relieved. And thereafter, page 150. 4-5 district, Chirang district also.
Page 150, Lordship will find that, my lord, the inspector of schools, Kamrup, my lord, they have relied on that 4/8/2018 notification. And my lord, the grade pay has been accordingly fixed.
We are also praying for this thing, as per our
Yes,
entitlement.
Mr. Katunia.
And their second prayer is also, my lord, with regard to notification dated 2nd July 2017, 2018. That is also on record.
4-8 notification, that is silent about the madrasa.
We have released insofar as
Kamrup district is concerned.
Kamrup is concerned.
Page 162, many Morigrao district, 4-5 district, I have annexed all the orders.
On what basis? It was released, my lord.
Now under.
My lord, may I pray for one thing, my lord? Whether they are continuing getting it or not, my lord, because maybe subsequently
they are
maybe withdrawn, my lord, because in the affidavit our stand is that this notification is not applicable in respect of matters. So whether they are still getting the amount or not.
Currently, we are under secondary education department, lordship.
Where is the notification?
Notification.
Where is the notification?
Page 80, lordship, page.
That notification, my lord, 4/8/2018, issued
Yes.
by Finance Department.
Page 80,
Lordship
annex 14.
will get it at page 231 of my affidavit. Running page 231.
In repetition, it is page 80.
One will do
Yes, ma'am.
230.
Currently, we are under secondary education department. Now we are MA school. No, no longer as pre-senior mother.
You're praying for your arrear or your current grade pay? Both.
Oh, both, because since we are entitled, we have acquired the
So
qualification.
if the madrasas have been amalgamated into secondary school, they're covered. There's no question, only the respect of
It is
arrear.
under secondary education department. I have annexed document also. Under secondary education department. It is.
Why do you say it is in respect of schools? Lower schools? It is not, madrasas are not excluded, is it? Madrasas are not excluded.
Not excluded. But not mentioned in the notification. This notification only in respect of, my lord, LP school, then, my lord, junior basic and pre-primary.
Now these madrasas are amalgamated into what?
Under secondary education department, and they are ME school.
ME.
ME school.
So if it
That is
ME
page 173. I have annexed.
If it is ME school, then you can
Annex 24. I have annexed the document.
24.
Annex 24 of the writ petition. Page 171, Lordship. Lordship, may I have a look? There is no doubt about it.
Yes, Mr. Khatun.
Page 173. All the pre-senior madrasas shall be treated as primary, upper primary schools, and they will follow the academic course curriculum under NCERT Assam. The subject name of Holy Quran will be withdrawn from this school. These are already done, and all other subjects available in the primary and upper primary school, including the Arabic language, shall be added. Then administrative control, that is page 174, Lordship. There is nothing to be hidden, Lordship. I am very honest to the report. It is my duty. Para 4, Lordship. The administrative control of madrasa institution, including the staff, will remain with the secondary education department as before. There shall not be any change in the status, pay and allowances, service conditions of the teaching secondary education department for the safe custodian future one.
But here
Irrational law.
Benefit was given by the inspector of school, my lord.
Maybe
He is the authority, disbursing
The
authority.
affidavit filed by the director says otherwise, my lord.
assuming we take the affidavit of the director on face value. Fact remains that as on date, there are no madrasas. They are a part of secondary education. They are controlling authority is the director of secondary. So while you are giving them to the other trained teacher, you are excluding these teachers. Although they are now part of the secondary education.
In that respect, my lord, may I submit that, my lord, give me some time, my lord, so that I can confirm it with the director, my lord. Because in the affidavit, my lord, that aspect has not been dealt with, my lord.
No. Director has mainly said, as far as madrasas, there are no, director cannot perhaps give you any instructions of that.
But
Will direct.
Yes.
my lord, because since director has not mentioned anything about the madrasa, my lord, so maybe there is some time may be given so that I can obtain the from the
Not
public, my lord.
necessary. I have filed reply.
No, your file, he wants to,
He petitioner is relying on the strength of page 171 document, my lord, that is, my lord, issued by Secondary Education Department, whereby, my lord, they say, my lord, madrasas are now part of so and so. So my learned colleague may perhaps seek instruction from the department, because department, it is the
that's right.
department who, yes,
whatever,
department,
secondary
they
education.
will clarify.
Prima facie, it appears they are a part of secondary education. So they are entitled.
What is the need of?
You get it by 24th?
Yes,
We'll have it on 24th?
yes, your lordship wishes, but everything is clear.
No.
We are under
Okay.
second, currently we are getting salary pay under
Learned
secondary.
counsel for the part. Learned counsel for the petitioner submits that the petitioners are trained graduate teachers working in the erstwhile madrasas. Subsequent to the order of the government issued by notification dated 12th of February 2021. All pre-senior madrasa, senior madrasa, title madrasa, and Arabic colleges have been amalgamated and brought under the secondary department. So he submits that all Arabic colleges will be treated as composite higher secondary schools from upper primary school with modified name. All senior and title madrasas will be treated as high school and they shall follow the HSLC course curriculum of SEBA. The administrative control of the madrasa institutions, including the staff, will remain under the education within brackets secondary department. So he submits that under pursuant to this order, the petitioners are entitled to be granted the benefit of grade pay as trained graduate teachers in terms of notification dated 4th of August 2018. Stop. The learned counsel for the petitioner has also referred to an order passed by the inspector of schools in the district of Kamrup, whereby similar benefits have been granted to madrasa teachers. So the affidavit filed by the finance department reflects that grant of grade pay is to be governed by the notification dated 4th of August 2018. And this decision is to be taken by the administrative department. The administrative department in the present proceeding is the secondary education department, who has filed an affidavit stating that the notification does not throw light on the aspect of grant of rate pay in respect of madrasa teachers. So in this aspect, the learned standing counsel, Mr. N.J. Katonia, clears leave of the court to complete his instruction from the department and place it before the court by the next day fixed. Let the matter be listed again on 24th of May. Is recording. 24th.
Lordship, highly obliged. Just one date more, nothing else. Earlier, final judgment, whatever they submitted orally or in the written same. Deeply obliged.
May I please your lordship? Lordship, the petitioner rendered service for more than 17 years, lordship, under the Prevention of Infiltrators of Foreigners PIF scheme, lordship. The petitioner joined in the year 1993 and rendered service for 17 years, 2 months and 26 days, lordship. Lordship, there are provisions, lordship, there is provision that who rendered service more than 10 years till 20 years, lordship. There are provisions for proportionate pension, lordship. Hence this petition, lordship. And there are some common orders are also passed by this honorable court, lordship. Lordship will find at page 46, lordship. So those petitioners' case were allowed by this honorable court, lordship, with the criteria that those rendered service more than 10 years till 20 years, they are eligible for proportionate pension.
Here. So you are praying for similar order?
Lordship.
Similar direction?
Lordship. Lordship.
Here.
Your lordship, if your lordship peruses through affidavit filed by the respondent number 6.
Yeah.
Basically, the case of the petitioner is that he is basically a fence sitter. In that, all those cases, what has happened? If I may take your lordship to paragraph number 4, and I'd just like to read out. It is a fact from the second line onwards. It is a fact that the petitioner had approached the Assam Police Border Headquarters with an application for granting proportionate pension to him as he had served for this organization for a period of 17 years, 2 months and 26 days. On examining the application and relevant records pertaining to the instance case, it is determined that proportionate pension is payable after completion of 10 years of qualifying service in accordance with judgment order dated 28/2014 in writ appeal number so and so by the Honorable Guwahati High Court. However, the Superintendent of Police Border Srimantapur Guwahati has communicated to the Deputy Inspector General of Police for seeking necessary instruction clarification in regard to disbursement of proportionate pension to the petitioner. Subsequently, the Deputy Inspector General of Police Guwahati, while letter dated 3/9/2022, intimated that Sri Jogen Chandra Hazarika, the petitioner, is not eligible for proportionate pension and other benefits except GIS and GPF as per Rule 24 of the Assam Service Pension Rules. Now, if your lordship may kindly go to the annexure number C, paragraph number 84, page number 84 of the affidavit. Now, in this letter, if your lordship may kindly peruse through this letter dated 12/5/2022 to the Deputy Inspector General Police written by the SP Border. Therein, of course, in the similar case, third paragraph, your lordship, in the similar case, SI X Govinda Vashya, who submitted resignation and discharge from service on 30/5/2006 on his own request after completion of 12 years, 7 months and 25 days of service, had already been granted proportionate pension by the AG as per order dated 29/5/2015 passed by the Honorable Guwahati High Court in connection with WPC number 11558 of 2015. Next page, your lordship, the IG, the Deputy Inspector General of Police, Adam, he wrote back to the Superintendent of Police stating that with reference to the subject cited above, I am delighted to state that you have submitted a letter to this headquarters regarding proportionate pension, other retirement benefits in respect of Sri Jogen Chandra Hazarika, The head constable, Shri Jogan Chandra Hazarika, and the PF scheme of border organization joined the service on 1/2/1993, and he resigned from service on 27/4/2010. And he completed more than 17 years, but less than 20 years. Now, as per the government OM dated 21/9/2019, the proportionate pension should have been effective with effect from 1/9/2015. So, on last occasion, Your Lordship, I was actually directed to produce this particular
OM.
OM, Your Lordship.
Lordship, that OM is there.
This is 21.
Lordship,
21/9/2015. So,
that is
if your
19.
Lordship needs a fresh copy, I have a fresh copy.
This is 21 January 2019.
19, Lordship.
19.
OM is
It is with effect from 1/9/2015. So, this particular OM, it relates to proportion pension to the ex-servicemen who have rendered service in Assam Police Border Organization under the Prevention of Infiltration of Foreigners scheme, which is the petitioner. Now, the person
we
to the
resigned prior to that.
prior to that. So it has got a retrospective effect, not a prospective effect, Your Lordship. Here, the second line, however, this benefit shall be effective with effect from 1/9/2015 as decided by the government. So if he is aggrieved by it, he has to challenge this particular OM also.
And next line, Lordship, the provision is not applicable to those ex-servicemen who were appointed under PIB scheme on or after 2005, Lordship. But the petitioner was appointed in the year 1993, Lordship. And all those covered cases, Lordship, this honorable court considered the proportionate pensions for the other petitioners, Lordship. Likewise, Lordship, the petitioner is also belongs to same category, Lordship.
He was waiting for 8 years after the judgment.
Lordship, he is a very old person now, 76 years old person. He was not aware about the proportionate pension.
You show us the judgment.
Lordship will.
We have annexed that particular judgment in an affidavit, Your Lordship. It starts at page number 66, the division bench judgment. And thereafter, this was followed by coordinate bench of this court at page number 68 onwards.
Regarding proportionate pension, Lordship, in their affidavit, Lordship, the judgment bears the page number
In the
81,
writ
Lordship.
appeal, what happened? The writ appeal, he was granted.
In that writ appeal, yes, proportion pension was directed to be granted. At page number
Now,
67. Last paragraph number 11.
so when did he retire?
He retired in year 2010
No, no. Petitioner in
Petitioner.
the writ appeal.
in the writ appeal. Lordship, that is actually not clear.
12 lordship,
2012.
29 to 2012.
2012.
Yes, lordship.
This is before 2015.
Lordship.
This was before 2015. Even in the case of this Govinda Vaishya also, on last occasion, I was directed to obtain at page number 84, annexure C. Govinda Vaishya, he resigned in the year 35, 2006. But he filed a writ petition in the year 2015 in terms of this particular judgment only. He was given this particular proportion pension.
Where is that order?
That order is not annexed in this, but if your lordship peruses to annexure C, page 84, that third paragraph, in the similar case of SI ex Govinda Vishwa, who submitted resignation and discharge from service on his own request after completion of 12 years, 7 months, and 25 days of service, had already been granted proportionate pension by the AG Assam as per order dated 29/5/2015, passed by the Honorable Guwahati High Court in connection with WPC number 1158 of 2015.
Why is this petitioner now treated differently?
Because according to the department, he has approached belatedly, and this poem of 2019,
That is not the reply of the Deputy Inspector General.
Deputy Inspector General,
Inspector General is only view that he resigned from services in 2010.
10, lordship. And in our
And his notification is with effect from 1/9/2015.
15. That is
And-
Yes. Wanted to say
Lordship.
something?
Govinda Vaishya order is annexed in writ petition, lordship. Lordship will find at page 43, lordship. Page 43, 7A annex. Page 43. The SB border communicated along with the Govinda Vaishya's judgment, lordship, to the higher official.
Govinda Vaishya is close the line of WPC 1147. It is
Lordship.
1147.
1147.
Govinda Vaishya, lordship,
At
115.
page number 68, your lordship, of our affidavit. It followed 1147 of 2013. A coordinate bench of this.
All right, hard. It's taking for if that if like if the benefit it petition service yeah some order order after the central government scheme namely in bracket prevention of infiltrators of foreign EIF the year 1993. First one to be the point is rendered its service after the piece of the additional that for about 17 years because of health, because of ailments suffered by the patient, on 9/4/2010, for which the superintendent of police in bracket B Assam passed an order discharging her on 27/4/2010. The petitioner completed his services for more than 10 years, but less than 20 years. As you say, we have not made a big effect of one thing. There is a scientific he has
Page 46, Lordship.
in WP Read Appeal 289 of 2008, whereby by order dated 2008 court interfered with the order passed by the Internal Secretary and no, which order you're referring?
Lordship, at page 46, Lordship.
46.
Page 46, Annexure 9 in our writ petition, Lordship, which covers all the proportionate pension cases.
No, division bench order.
Division bench order is a counter affidavit, Your Lordship,
Counters.
at page number 66. It's order dated 28/2014 in writ appeal number 289 of 2014.
But the writ appeal did not interfere with the single judge's order.
No, there's a different single judge order. This single judge order of 1147 of 2014, 13, Your Lordship. It actually emanates from a Supreme Court judgment. With regards to this whole
Why
prevention
are
of.
you referring to this writ appeal order?
We have annexed both the judgment. Your Lordship. We have annexed the writ appeal as well as the single bench order, coordinate bench order.
What are you trying to submit on the basis of the writ appeal order?
Writ appeal order was basically similarly situated people. This therein the order dated 23/1/2011. So basically, they were in that particular case, full pension was payable after 25 years of qualifying service, and proportionate pension is payable after completion of 10 years of qualifying service. This was actually held by the division bench.
In that case, Lordship,
In that case.
10 years was not completed in the writ appeal.
In the writ appeal.
But in our case, Lordship, the petitioner completed 17 years.
And the single
After
bench.
10 years.
But you have referred to the writ appeal order?
No, Lordship.
Writ appeal annexed by us in our counter affidavit.
For what proposition have you enforced this order?
It was the case not completed 10 years in the writ appeal, Lord.
Even after not completion of 10 years also.
Strike out the Twenty-three. were allowed, the respective being completed more than 10 years, directed to be granted from the the state court bench also reference to an eligibility, judgment of the writ, judgment passed in the appeal by the judgment. We deny of the I have paid it 008,000. The court may tell that both the petitioners therein having completed 10 years, right? Waited. However, it has been rejected without considering the judgment of the people. I think very the rejected the claim of grant of pension, the reputation on the ground that the office memorandum dated 21/1, which by which proportionate pension was decided to be granted on the cabinet decision taken by the state, not if case of when has been made effective from 1/9/2015, whereas the pension has been 27 for dead. State letter not disputed that petitioners have been more than 10 years. Coordinate judgment taken by the have clearly had that the petitioners therein have right if the facts of the did not department has cleared the case, the others would whereas the case would say that the now has been made effective from 1/1/19 having retired, resigned or retired prior to retired prior to the effective date. The order class is quoted in that you that claim the very high.
Lordship.
Lord.
Highly obliged.
May I please, your Lordship? Herein the husband of the petitioner, he retired from service on 31/1/2008, and thereafter the pension was revised, and the husband died on 2/1/2021. But no pension has been granted to the petitioner, although the petitioner approached before the respondent authority claiming family pension in respect of death of her husband. But in response to this read petition, your Lordship, the respondent have filed affidavit. In their affidavit, they have stated that the pension, in the pension payment order, the name of the petitioner was not mentioned as family member of the deceased employee, and accordingly pension, they could not, no such pension has been released to the petition. In the last occasion, when this matter was listed before your Lordship, and on that day, I was asked to place some judgment regarding non-inclusion of the name of the petitioner in the pension payment order that cannot.
Whose name is there? Nobody.
Son,
Only son.
he is a measure now. That's it.
If the measure is not right.
Not in that. And the procedure laid down in the Assam pension rule, the petitioner husband have to give the details of his family members. Is 148, my lord, pension rule. One 48, lord. In my book, it's page 168.
Yes.
Lordship, may I read? Procedure. Furnishing of family details, 148(1). The following procedures are to be followed in respect of claims arising out of the scheme in this section. 1. All non-gazetted employee entitled to the benefit of this as defined in clause 1 of the rule 143. It is the Lordship family pension 143. That is the date of birth of the each member with his her relationship with the government servant. The statement shall be countersigned by the head of the office and pasted in the service book of the government servant. Government servant will thereafter be required to keep this statement up to date. Additions and alteration in the statement will be made by the head of the office from time to time or receipt of information from the government servant concerned. Then all gazetted officer will furnish the details. Then Lordship may skip this. Then the cases where death occurs after retirement, Lordship, in order to facilitate quick payment of family pension to the widow of the pensioner, the same pension payment order under which the pensioner was drawing his pension was provided for the admissibility of the family pension to her. For applying for the grant of pension, the government servant should furnish 3 copies of his joint photograph with his wife. Nothing has been provided by the government servant in this case, my lord. In fact, her name is not included. And in fact, Lordship, there is a case is pending. The petitioner is well aware whether there is divorce or not, because I have record to show he has given the maintenance to his wife. If there is divorce, then
I have
yes,
made a statement, your Lordship, no such divorce there was. And they have also stated in their affidavit that maintenance was given
Yes,
to
yes.
the
yes.
wife.
But after that, what is
But
the
as per
outcome of the
section on
case? When-
41, Your Lordship, the turn of the wife will come first. As per section 143, Your Lordship. But herein the issue is, the name of the petitioner was not mentioned in the family details of the deceased employee, Your Lordship.
Is there any provision that what happens if is not mentioned?
There is nothing mentioned in this rule, my lord. I have gone through. Because all the government servant has to give their family details in the service book, and they have to up to date their service book to give the current status of his family. But nothing has been provided. In fact, nothing is a record
But
to
if
show.
there is a judicial order,
Then lordship, then the lordship may direct the petitioner to approach the registrar lordship with all the documents she have if she is not divorced yet.
No, I
Then
have made that.
We have
statement,
no
Your
objection, is my lord may
If your
verify us. We have no objection, but in this rule, this provision is not there, my lord.
If your lordship will.
you have to read 148 and also 143.
143, yes, the wife is the first. Is, but what is the outcome of the divorce case?
If mention is the first as per the name of 148,
Yes, my lord.
then what meaning he ascribed 143? Why a definition is required?
But why the petitioner husband did not nominate
Even he did not, he can't
But-
compare.
that lordship? This is a matter of fact, but there is a dispute in between the husband and wife, I think, because
Maybe, but there divorce or not, subsequent, the husband is there, there is no question of divorce.
yes, well, lordship, this is nothing is record to show that petitioner
Who is for the son not objected, he's not objected.
son is not a party here.
But
And he's a major, not now, he's not entitled.
Yes, 13, your lordship, kindly see, this is the death certificate of my
Father
husband.
and son are together.
Lordship.
When did you claim your pension?
I claim in pension since after the demise of my husband, your lordship. Page 13, your lordship, kindly have a look. This is the death certificate, your lordship.
Is there a marriage certificate?
No, death.
No, marriage certificate.
No.
Where is the order of the court granting you pension?
That is
maintenance?
That is in our
page
affidavit.
18, your lordship. Page 6.
Eight?
Page 18.
Huh?
1-8. Page 18.
দাদা এখন
What is this?
The petitioner has received the maintenance amount. They have given the signature. After that, what happened? The divorce case, Lordship, the department is
No,
not.
there was no any divorce case, Your Lordship. Maintenance case is something different and divorce case is different. No such divorce case there was.
Yes, you have any other report?
Yeah.
No. In para 11 of my petition, Your Lordship, I have my statement, Your Lordship. There was no any divorce, nothing.
Oh, that's okay. The interpretation of rule 143 vis-a-vis 143.
Lordship, in page 13, Your Lordship, this is the death certificate, Your Lordship, and wherein the name of the petitioner is mentioned.
That you had some judgment.
Yes.
Where are the judgments? Let us see.
Lordship, judgment one. Hiron Politama.
Yearship certificate. Have you got a yearship certificate?
No.
You obtained that and place it before the authorities.
The legal hair certificate, Your Lordship, I have annexed here in the petition.
Inoperative.
You have the legal year.
Yes.
Legal certificate to accept.
Okay.
Kuntu
Next in certificate says 16 Your Lordship.
Yes.
Lordship, the next of kin
One more
14
Your
to
Lordship.
2022 after demise of her husband.
Huh.
But in the Lordship, I kindly have a
That should
look.
be after demise only. Yes.
Lordship, in here, one more judgment is there, Your Lordship. In this case also, the name of the petitioner was not mentioned in the family details of the pension payment order of the deceased employee. And thereafter, writ petition was filed. In the said institution, it has held that this court finds that the non-inclusion of the name of the petitioner by her deceased husband in the nomination form cannot deprive the petitioner from the receiving what she should rightfully receive when she has not been divorced by him. And subsequently, it was appealed, and the full bench, I think Your Lordship was also there. In the full bench, the same view.
Judgment. Why are you asking? Shall it take you from your memory? Why don't you produce it before the court?
Lordship is
What are the judgments meant for if they are not placed before the court and argued?
It will favor the case of the petitioner. Lordship is ordering that. Hiron Politama.
No.
143 is applicable, but they have petitioner have to prove she is the wife of the government company. No?
This is on the ground that some other
Person has been nominated. But if the petitioner has document to show if she is the wife of the deceased government husband.
legal certificate, you are not disputing it.
That Lordship, petitioner may produce the family court criminal case number 10892, the outcome. And my lord will 108 of 92. This is in my affidavit that we have stated. Then the picture will be clear. If there is no divorce, only maintenance, then
This man has already expired. Where is the question?
earlier, Lordship, the matter of 92, I'm not aware what is. I have charged in the
relating
online.
to the maintenance, Your Lordship. If I am
Only maintenance, then I am not aware. Lordship, in paragraph 10, my lord, page 28 in my affidavit.
108.
in my
That 108 case number.
process,
In page 41 of their affidavit, your lord.
no,
There,
28.
page 18 of the repetition. That is
Lordship,
there.
in my affidavit, page 28, paragraph 10, my lord.
What is the case reference?
Lordship, FC criminal number 10892.
You come to page number 18.
18 of the repetition, my lord.
Yes.
This
The
is
order.
92, final order.
This is the order FC criminal 108.
After that, I have spoke to the department also. They said if petitioner has approached us with some valid document, then we have nothing
You
but.
tell the petitioner what valid documents you want.
Yes, Lordship may direct them to produce something at least.
What document?
Because in our office
You
record,
say that this document X, Y, Z, this
and the
document.
marriage certificate, etc.
There's no marriage certificate. There's no marriage certificate. But there is an order of a competent court granting
Maintenance. Yes. Other may direct. They have no objection if, because there is
Regarding
his,
marriage certificate, your
her
lordship.
name
Page
is not
21 on birth
in
certificate, your
the,
lordship, of my son, I have an.
Hmm?
Page 21, this is the birth certificate of my son. So marriage certificate is not.
Lordship, if the petitioner made the son is a party here, if
No, son is already.
no, for not a pensionary benefit, but he may inform this honorable court what is the status, whether their parents were separated or something else.
I've done it now. Sir. Registrar of site. Well, 1967, and it's superannuated on 31/1. It subsequently expired on 1/20. Pursuant to the demise of the dead husband of the recipient, she approached the department for living pension. Subsequently, she came to be informed that the PPO, is the name of the son of the petitioner. It submitted that son is already the major, and there are 3 other daughters who have also been married. Therefore, none of them are today eligible for family. The petitioner claims that the legally wedded wife of a Prabhat Chandra. Therefore, her claim under the Assam Services Pension Act 1989 required to be redressed, and she required to be given family pension. It is submitted that the petitioner has applied for and has been granted next of kin certificate dated 13, whereby it's by it provides thereabout the other order dated 28/3/2007 past date MC criminal 108 of this case 381 of 2009 by the court of the family judge, family court of the by the same order, the family court principal judge family directed payment of maintenance to the petition by earlier council. So, earlier council that this order passed by competent judicial authority reveals that the petitioner is a wife slash widow. Therefore, the petitioner is entitled to granted the family pension as per of the services paid. It's submitted that the same not have been granted. Current council judgment of the apex court reported in DL Media. Submit that
Right.
where the rights of departmental government by statutory provision, individual nomination, contrary to the statutory provision, is also relied upon the court rendered in page 1B. This is given in India reported in 2001 report. So the same. Standing council. What department?
Cooperation, my lord.
Cooperation. Submits that as far as the department is concerned, they had released the pension in the favor of the son as his name was reflected in the nomination. There are no other documents in the service record of the description of the state husband.
My lord. And a joint photograph for family pensioners.
Why? Or the Indictment. Right. Why? Moreover, and order by and the key. However, not particularly of the democratic even otherwise after failure of the evidence, failure of the evidence, the evidence, not taken place, not taken the right place, the event made the very by judgment that court that have made step back that and the way ahead and the direct made the order path believe that edit final by that hard however subject not the of the by no but and no evidence that that is document something but having the same verify that that and if if that if if the if the authority claim of the legally verified then every area like no area
Area, yes, there is area also.
How?
Because,
we're passing the order to
yeah, because husband died on 2021.
You did not apply.
No, we apply your lordship immediately after death of husband, your lordship. She approached. No, reject your lordship, therefore only your lordship we are in here.
Where is
They
the
have
rejection?
rejected.
Where is the rejection of?
No, there is no any formal rejection order, your lordship.
But in our affidavit, you stated no one has approached the authority. In paragraph 9,
Pension, family pension. Now, that- the case of that.
deeply obliged, lordship.
But the petitioner will approach the authority as expeditiously as possible and upon such parties within a period of 60 days from the authority.
My lord. Lordship.
Obliged.
Deeply obliged. Lordship, I have a small prayer, my lord. In today's cause is item number,
Yes,
lordship, today's cause is item number 10. I have been told transport is a party, but no copy has been served to me, my
we
lord.
have directed some,
Lordship,
directed them.
reflect my name, lordship. I'm so deeply obliged.
Yes.
So, Lordship, can you schedule the order dated 17/11/23? 17/11/23. Let's see, arrears was. State that no affidavit has been filed in this.
Where is health? Is it health?
No, yeah, yes, higher it is.
Higher education? Yes, your submission is reflected in the order 1711.
Yes, Lordship, but the direction was issued to the respondent number 6 for.
You are permitted to file an affidavit.
Okay.
Accountant General, any information?
I have received one inspection notice. Because this is not compassionate family pension, that's why she cannot be entitled.
This is not
Compassionate.
It is just a regular family pension. Had it been a compassionate, she could have proportion, certain proportion could have been given to her. Because the administrative department sent the name of the respondent number 8. So since it was proper, we released the pension.
What is the difference between family pension and compassionate?
Compassionate family pension, that is under the scheme that has been attached to the refixation law. At page 43. And these two, and the regular pension is under 143 per annum, located 143.
So compassionate family pension is in lieu of compassionate appointment.
From that, she will get something.
Who has applied for?
So this was sent by the administrative department. That is the principal sent the paper to us
For
or the
family
director
for
or the
family
director
pension. For family pension.
for regular family pension. So we issued them since the papers were improper and her name was there. That's why I lost it.
Yeah, who is for the private respondent?
They have not appeared. Nobody has.
Nobody?
Nobody has appeared. We have taken also justice service also.
No one has appeared.
Nobody has appeared. Justice service also I have taken.
He's also working as a headmistress, no?
Yes.
Who?
That lady,
private
lordship, the
district.
daughter-in-law.
No.
Wife of the district. Yeah. Government employee, but
Social delay, lordship.
77 years old is a
You are residing where? Where are you residing?
I'm visiting my house there, but the wife of my daughter-in-law is living with resident
Separate.
separately. After 2 months of the death of his husband, he left to her parental house. Same village, but he's living separately. Without
All
looking
right.
at her.
In spite of the notices being issued,
Those two services I have taken, I have filed a activity with also. They also received the copy. And now it's all legit, because no fully dependent of.
where is the respondent servant working?
She's the headmistress of LP school here. Then Palhadi, Gobrapara LP school here. In the
So
district of Borpeta.
why higher education is there?
No, this husband is the.
Husband was.
Is the associate professor.
Heard. Counsel. I claim the return of family pension. And she claimed to be dependent, mother, entirely dependent on her son, who expired. Pursuant to the expiry of her son, the daughter, namely the respondent of 7, started living separately and had applied for family pension. So family pension is granted. However, the petitioner has not been drafted or is not been drafted any share of family. 143. But it is to be granted to only one person, family pension.
Not.
Is to be granted to the family.
First preference wife.
Wife.
The absence of wife, the husband, in case of the absence of wife, and then come to father, mother.
Mother nowhere figures.
Mother is there, but below left.
Where?
158 years. It's amended here.
Huh?
Amended. I'm giving you.
But this is not uh, only one person is to be given the pension.
One is a receipt and they give distribute. Receipt is only for. Mother is 77 years.
Huh?
Mother is 77 years. Yes, she is bedridden here.
There is a different act under which we should seek redressal.
No, yes.
There is a different act under
No, Pranam
Novata.
is the yes, this petitioner, the serviceman. is not look after his father, then tournament is given to that. If a person is under service, in service, he is not
He-
after.
The respondent 7 is under service.
Sister-in-law, it is not covered. Not
Sister is or daughter-in-law.
daughter-in-law, daughter-in-law.
Huh?
Daughter-in-law is not covered, not
Not covered.
covered. I
Must
think
be
son and daughter
son and daughter will be continuous daughter.
sometimes
Not even endless the definition.
Huh?
Endless the definition including them also. That will need a judicial interpretation.
Where is the amendment? You have the
amendment.
वो अपना
EF, father, mother, that something. Stop here.
being agree with the is submitted that steps on respondent 7 have been depicted and represented by the respondent 7. Considering that claim of share of employment by the mother of the deceased government servant claims to be about 77 years and was and is stated to have been completely dependent on the deceased government servant. And also taking into consideration the submission made by the council to the bar that the respondent 7 who made the submission?
I have made it. Notice, sir, that
He is- no, no, no.
No.
He is an employee.
employee, your lordship.
That has been stated in
Stated.
Your lordship.
Where?
paragraph 3.
And since it is stated, the writ petition that the respondent.
Page 6.
Huh?
Page 6, copy, paragraph 3. yeah, but Respondent 7 is the
Is
headmistress
the
of one.
headmistress of 1688 number Al Haji Gobrapara LP school. That is receiving good amount of salary there. The court considers it appropriate to complete the. This is what LP school will be elementary. Elementary education department. So, where is the council for elementary education? Mr. D. N. Sharma. Yeah. The petitioner will take steps through the elementary education for service of police or private responsibility. Copy of the writ petition along with the copy of the order be served on the through the director elementary education on the respondent number 7 within a period of 2 weeks. In view of the order passed by the registry will array Departmental
Elementary.
Department of Elementary Education, Secretary to the Department
Secretary.
of Elementary Education and Director Elementary Education as party respondent number 8 and 9. The writ petition. The United Council for the petitioner will serve extra copies of the standing document, enabling the necessary orders, instructions. You inform him that the matter be listed after weeks.
It's okay.
31st March. You can take back this instruction.
My lord, let me please, your lord. Matter pertaining to suspension, the petitioner, my lord, was placed under suspension by order 6/7/2022 for a response number 3, the deputy commissioner. By exercising power under rule 6(2) of the Assam Services, December appeal to 1964, taking plea of being detained in custody more than 48 hours, my lord. So the deputy, the response number deputy commissioner is concerned, my lord, he has no any power to suspend the petitioner as he is not the appointing authority, my lord.
The petitioner works under which department?
Panchayat, my lord, Algapur Gaon Panchayat, under Panchayat and Rural Development.
He is an employee of the Gaon Panchayat.
Gaon Panchayat, my lord. Well, page 22, my lord, page 22, my lord, is the order issued by the Commissioner Secretary of the Government of Assam, Panchayat Department. Hereby, my lord, those scheduled employees who were engaged prior to 1/9/2005, my lord, they were allowed to draw fixed wages, remuneration at a rate of 15,900.
Where is your appointment order available here?
Yeah, this is initial appointment 1998, that is, yes, my lord.
Page number?
Page, my lord. Page 21, my lord. First, my lord. Page 20, my lord. That is why Algapur Gaon Panchayat president, my lord.
And then
As a tax collector, my lord. Then it is my page 21, it is my lord joining report. Then 22, my lord. This is order issued by the Commissioner, my lord. In pursuance of the merit, my lord.
yes,
In pursuance of the government order, so and so, so and so, so and so, read with financial department notification, so and so, so and so. The following casual employees under Panchayat Development Department who were engaged prior to AFRDM period, that is 1 September 2005, government notification number so and so, so that is 26/2000, 26/8/2005 are allowed to draw fixed wages remuneration of rupees so and so with guarantee allowances, which will undergo revision whenever pay scale charges based on enhancement of DA and recommendation to pay commission along with the medical allowances of rupees 6 per month, my lord. The periodicity fine petition next page, my lord. Serial number 51.
okay.
So what is the, my lord, FIR is concerned. In that FIR, my lord, police investigating the subject charge sheet, giving clean sheet to the petitioner, my lord. And that, my lord, and thereafter response number 5, issued a communication for a response number 5, saying that if the police has given out a clean sheet, my lord, therefore, my lord, the drafting of charges against the petitioner does not arise in this case.
Now let us understand.
My lord, no, my lord, condition latest order, my lord. DC requested the, my lord, response number 4, that response number 3, deputy commissioner. No, sorry, my lord, chief executive officer. General instructed him to reinstate the petitioner because he is unable to reinstate him. So he written a letter to the response number 1 to reinstate the petitioner, my lord. That I subsequently received these copies, my lord. My lord, Perak Thape is fine. The block development officer, Algapur Development Block, submitted a report, so and so, along with a copy of charge sheet prepared by the officer in charge. Algapur Police Station, Hailakandi copy. So, he stated that subject of case is misutilized of flood relief material by custodians of the materials, but as per the charge sheet, Farid Ahmed Chaudhary had already handed over the materials to booth level officer before the incident ends. drafting of charges against him does not arise and same forwarded to Deputy Commissioner Hailakandi by letter dated 18/2/2023. After that, Deputy Commissioner Hailakandi instructed to this office, that is response number 3 office,
That is okay. Now let us understand who is competent. Committee.
only the commissioner, my lord.
And then, what do you say, Mr. Or? Does the appear competent unless say that there is some particular thing?
Yes, my lord, if I go by the appointment, my lord, yes. DC is not the appointing authority. That is, my lord, it's a fact. That is there.
If there is instruction, necessary, or we pass an order.
They also filed affidavit by respect of DC, my deputy commissioner,
There
but nothing about, not,
also power is not explained.
but nothing has been explained to that effect in that affidavit. For last 2 years, but he's under suspension, continuing under suspension now.
My lord will pass an order, my lord, or my lord can send it back to the DC. He will take a decision now in a time frame, my lord. What is
Can
the
he take,
But he said it, it is not authorized.
Well, this matter may be disposed of with the direction of the commissioner to pass a speaking order as far as the reinstatement is concerned, because this order will be set aside anyway. DC's order
The suspension by the DC.
DC?
is an invalid order.
Be set aside. So the DC has to withdraw or pass an order reinstating. Now, if the DC is not empowered, that order by itself explicitly says, where is the question of again directly the commissioner or any other officer reinstating?
But in that case, he will get reinstated. Fine.
No,
That's
we first we tell us that the power
not as far as the position of law goes. The suspension can either be suspension order can be passed either by the appointing authority or by any authority who is being delegated with that power.
where is the delegation?
There is no delegation. There is no notification. DC has only been authorized to transfer. Only transfer contractual employee, casual employee, whatever be the nature of the employment, they are only delegated. They have only power to transfer, not suspend. There is no notification of that. It's a bad order.
You admit it is a bad
There's nothing in the act. The disciplinary authority, as far as the staff of Gaon Panchayat are concerned, as per section 30,
no, it's not there in the act. There will be particular.
there's no, not to my knowledge, my lord.
No, my lord. That is the problem. That's why my lord, I'm in back foot.
And in fact, it is written in the suspension order that will be suspended under 6(2). Discipline and appeal rules, my lord, do not apply to casual employees.
Casual employee.
He's a casual employee.
So there are two packets. Whether it applies to casual employee or not is one aspect. The other is whether even if it applies, whether the DC is the competent authority.
He's not the appointing authority. The president would have anyone authorized.
By Sailing. The ropes is employed as
casual employee in Algapur Gaon Panchayat
casual employee under the ALGA
In the district of Hailakandi.
in
District Hailakandi.
in the district of pursuant to some allegations made against the petitioner was placed under suspension by
Page 38.
order
6-7.
order dated 6/7/2020 by the Deputy Commissioner. Under counsel that the petitioner is an employee under the Departmental. Therefore, the C does not answer, not the competent authority in cases. He further submits that a petitioner is casual employee, therefore the provisions of the Assam Assembly well, the respondent by respondent that's by respondent number 3. An affidavit has been filed on behalf of respondent by the petitioner. It states affidavit, however, does not go any light the source of power that the C suspended employee and of the child employee. So, learned counsel have an advocate appearing for the state, Mr. R. Ford, as well as take that fairly submit that there is no office memorandum or notification empowering the deputy commissioner to suspend employees belonging to other departments. The notification available at present is only empowering the deputy commissioner to transfer casual employees and contractual employees, etc., within the district. However, that notification does not empower the deputy. Well, so the provisions of the Assam Assembly are suspended right now. 6. The appointment of any other person delegated with the authority is considered issue order basic employee and the suspended. The rules make it very clear that it is the appointing authority or any such specific delegated on whom the powers have been delegated, who has been empowered to suspend. It is apparent from reading the report that the petitioner is an employee, casual employee under the ALGA government Act, and his appointment issued by through the office of the that it will be it's clear that the petitioner is an employee under the revenue department or under the admin or Well, that- that-
Let me add one. The department may be given the liberty to draw departmental again.
Why do you want that? But only proceed. Right.
Right. Right.
What is this notification?
Communication between the CEO and the Commissioner PNR.
Is both.
Right.
Lordship, issue is here is very simple, Lordship. Whether the SP could have interfered with the order passed by the DIG, Lord.
My lord, we have received the instructions, we need to file affidavit. My lord, 2 weeks time may be given, my lord, in the meantime, we'll file affidavit. And on the next day, it will be disposed of, my lord.
Should be the property available. Submits that instructions that they receive, you like, right? That report would be this. Enabling the respondents to file.
Yeah, we have sent the affidavit for vetting, Your Lordship.
Yes. What is the issue here?
My lord, here the petitioner was dismissed for some service.
Dismissed.
For,
File, you
for-
filed an appeal. You
Yes,
filed an appeal.
yes, yes, we
It's
filed
been
it.
rejected.
Rejected.
The matter will have to be heard.
My lord, they are supposed to file affidavit.
That's right. It is
Fine.
the, you are questioning the dismissal order, inquiry,
That's, that's
appellate order,
when,
everything.
because of unauthorized absent, whether it is willful or not, that is to be decided.
Right, so the records will have to be verified.
That is why my lord, they took time for filing affidavit and.
No, you are questioning the departmental proceeding
Yes,
itself.
yes.
So the records of the departmental proceeding would be required to be gone in.
Might.
So this will require hearing, in-depth hearing.
But first, let them file the affidavit there.
Let them file. In the meantime, even if they don't file, the records are sufficient to decide.
But that
Call
also
for
can,
the record.
that also can.
So we issue rule here.
Can it be,
Issue rule.
can we date may fix for another, because
Issue rule. Records we call for. The respondents are also permitted liberty to file their affidavit. Matter be posted for hearing. On 18th June.
18 June. Might.
Yes. Okay, the matter is related to the transfer of a casual employee. Okay. On page number 13, the annex number 1, petitioner was appointed as office assistant on casual basis. Posted at Dula Kakuria Gaon Panchayat.
Yes.
Therefore, Lordship, while the petitioner was working, an office order was issued against
transferring the employees of Gao Panchayat on 15th June 2023.
Where is that order?
Lordship on, may find out Annex 2, Lordship,
Page 17, my lord.
page 70. Okay, we find the name of the petitioner on serial number 15, Lordship. Montu Gogoi, office assistant, casual, Lordship. And all other employees are regular employees, and the petitioner is the only employee who is casual.
Then?
Therefore, Lordship, the transfer order was kept pending in the office itself. The petitioner was not communicated at the time when the transfer order was issued. And the transfer order itself is a malified, Lordship.
Right.
Lordship, the transfer order was issued, the petitioner was transferred because in their affidavit in opposition, they have stated that the petitioner was transferred as a measure of punishment, Lordship, which is illegal. That, Lordship, they have filed the affidavit in opposition on February 2024, but the affidavit in opposition is not in the record, Lordship. They have filed, they have furnished a copy to us, but they have not filed the affidavit in opposition. Lordship.
My lord, the standing counsel N.K. Devnath was handling this matter. Inadvertently, my lord, he had supplied a service copy to the petitioner. He failed to file it before the registry of this court. I've taken a copy from him today. They have supplied me a copy. But however, the issue of law is very clear, my lord, here. I have this notification.
He filed a reply affidavit.
My lord,
Yes,
I've read the reply.
Lordship, kindly see the order
I've read the
dated,
reply.
Lordship.
Huh?
Kindly see the order dated 10th January 2024 of this honorable
I'm
court.
relying on this notification. It has not been set aside till date, my lord. All staff. This order was issued in May.
And this order was issued.
This was passed in June at page 17, my lord. Authorized by the DC at page 18. It has got the authorization of the DC
If
6
you want to file your affidavit, you bring it on record.
I'll bring it on record, my lord.
Lordship, they have stated that on the of this honorable court order, 10th January 2024, my lord.
You kindly provide me a copy of the affidavit.
Stated where?
10th January 2024 of this honorable court order, Lordship. Order dated 10th January 2024. The learned standing counsel PNRD submits that the instructions as sought for have been received. He is required to file an affidavit on behalf of the department. He placed 3 weeks time notice. Thereafter, on the next occasion, it is submitted by Mr. N.K. Devnath, learned standing counsel PNRD department, that the affidavit on behalf of the department has been filed today. And the same copy of the same was furnished to us. But in record, it was not filed, Lordship.
Verify.
And we have filed the reply to the affidavit.
You have a copy of the affidavit, right? My lord, may I peruse the affidavit if my lord wishes to? Can be disposed of that ground itself.
It is submitted to the bar.
The affidavit of the buyer.
Like, that by order in the time. Reported that the affidavit are filed. However, state affidavit. Number 5. The key and take the special copy. Yeah. So the verb we don't need this. Once you file it. the copy, maybe if it's up to- it's up to-
Lord, already the respondent number 2 has submitted their response and objection they filed, and they say that like Gauburas are not like appointed as proper government employees. They're not doesn't fall under any. It is in page number 97 of their submission, my lord. They say that Gaubura do not fall under any service condition of any other government employee. That's what it is. My lord, in this case, already 2 orders has been regarding their appointment is been filed. One is from division bench in page number. My lord, in page number 60, my lord, a judgment from your honorable court only, nothing in a court. And then there, in page number 64, it has been clearly given, my lord, that government of Assam has decided the outer government of Assam is the employer of the Gaunburas. That has been specifically mentioned there. My lord, if we go from that point, then if we go to see what is the who are eligible to get pension, madam. So we are basically,
You have,
no. So basically, we are government, that is been declared that we are civil post holder, and then we are, our employees, employer is government of Assam. So in these circumstances, if we go to the Assam service pension rules, and then see section 31, there might not, who,
require some hearing.
pardon me?
This will require some hearing.
Lordship, even then, my lord, the maintainability of this petition, my lord. The Lordship may kindly goes to the page 2, Lord, of paragraph 2, Lord.
Of?
Of this writ petition, Lordship.
There are
Lordship. There are only 2 petitioners. My lord, how can they represent the others, other Gaunburas, Gaunburas, Lord? There are 93, or out of 95,
93 almost.
there are only 2 are filed this petition.
Or representing them.
all right, they are representing their own case.
Yeah.
My lord, they say that they are representing all the my lord, that other Gaunburas, Lord.
There are other Gauburas who are having the same plight and.
And even then, Lord,
conditions.
kindly goes to the my lord, their appointment, Lord.
Not a PI.
No, this is not
No,
a
it's
PI,
not a
Lord.
PI, Myra, I understand that.
And it's not filed by some association.
No, it's not association. These are the 2 persons who has filed this petition for the plight of them.
Will be confined only to their right.
That's what.
Lordship.
That understand.
And even then, my lord, there are other all Assam Gaunbura association. They also file regarding the pension, Lordship, that has been, my lord, withdrawn after, my lord, filing the affidavit.
Because they do not have their registration and all these things. But in this case, these are 2 individuals.
Very well, we'll keep it for a hearing date.
Lordship.
Sit on.
And these are senior citizens and they are dying one by one actually without any getting anything compensation and all this. The situation is very pathetic.
21st.
21st of this month. Your blessing.
My lord, in this matter, we have filed our affidavit. If they want to file reply, my lord, fine, my lord. Or also fix, my lord.
Even after 3 months, my lord, they did not review the suspension order.
My lord,
That is
before
my
3
case.
months, DP started, my lord. We gave so cause
Only
and
started DB, my lord. There is no finding, my lord. In conclusion, my lord. Prolonged suspension, my lord.
For how long?
My lord, suspension order is page 34. 2005.
Do you want to file any reply or?
My lord,
they have annexed some documents, which is I already annexed in my repetition.
Question put to you is, do you want to file a reply or not?
Yes, my lord, then my lord, 1 week maybe.
The day after the account. It's time to file. Reply to the application. That's all. Week.
Right.
Wait, please. Meta parents non-payment of pensioner benefit. This honorable court has passed an order on 10/1 directing to pay the provisional pension to the petitioner. But till date, no, nothing is done by the respondent. No affidavit. No, nothing.
I am
Today is
waiting
for
the
instruction,
pension
madam.
department respond number 3, and I have received instruction that the pension department has got working.
Yes,
I'm for KAC, Lord.
yes, what do you say?
Lord, so in this, I need some time to file my affidavit.
You have to file even sufficient time
2 weeks time maybe.
on 10/1 itself. We have given you time. 3 months. Yeah, you have not filed anything. Most importantly, direction was given to pay the provisional pension. That was not followed. The respondent Karbi Anglo Autonomous Council filed their affidavit right in a period of
2 weeks.
2 weeks. The release of provisional pension, he also considered the the question, the possibility, the claim of the petitioner for release of provisional pension, he also considered, and by the next day, the standing council apprised the court.
The provisional pension that will be looked up by the government, Lord, not by the KAC. Lord. And we could not give a pension.
By government whom?
By the director of pension.
Director of pension will come later.
Director of pension, we have received letters, we have got mobile.
You have made accountant general also. My lord, one letter has been issued by the accountant, that's why, my lord. Director of pension is a party. No, my lord. Not a party.
Party, your lordship, respond number 3.
Yes, my 3. It is after 2 weeks. 2 weeks. Can you fix it late, man? 31st. Okay.
Bibliography.
Here, your lordship, we have received the records and we have filed the affidavit. Lordship, the records are today not with me, your lordship, it is in the office, so your lordship may take it up on any hearing day, your lordship.
Any reply to be filed?
Lordship, I have yet to be received the detailed CPDP, Lord.
Huh?
I have yet to receive detailed CPDP. As per order dated 22 February 2024, Lordship, your Lordship has asked to file detailed CPDP if required.
Records were called for, your lordship, we have received the records. 21/2/2024.
I have not received detailed CPDP file, Lord.
Affidavit has been filed, just the annexes were not annexed. That's why records were called for.
Your Lordship order dated 22 February 2024, Lordship. Whoever asked to submit detailed CPDP if the government has wished to file, Lord.
Where are the records?
The records we have received, actually, it's not with me today. Some other day on any hearing day, your lordship.
Yes, Lord. But if the record will be submitted before this court, Lordship, copy
Records
should
itself
be
will.
furnished to me,
because-
Lordship. I have not received.
What?
You have not received affidavit of opposition.
Yes, Lordship. Only
Affidavit of
the
opposition?
affidavit, Lordship, I have been received, Lord. I have received. So details report, Lordship, if they have.
Record you will not get, you can only have the liberty to vote. You will not get copies of the record.
Yes, please.
If you want the record,
Yes.
let it be on 30.
Deeply obliged.
May I please, your lordship? And this matter is relating to pay protection. And they are supposed to file affidavit, lordship, no affidavit.
Yes, Mr. Khan.
Yes, my lord, I'm paying for some time, my lord.
Order 365 by elementary.
Secondary, my lord.
Right here.
If I'm appealing for respondent number 5.
Just after 3.
My lord, any date may be given.
Okay. 7th of
Obliged.
May I please your lordship? The matter pertains to non-payment of superannuation pension. The petitioner was serving as a master roll worker and his pension has been denied due to the deducting of 6 years of initial service. He has completed 25 years, 29 days of service. Sanjita Lord.
yes, so the respondent.
PWD has.
My lord, the issue here is, it's a Karbi Anglong matter. The factual aspect has to be confirmed by the, they are not,
Karbi Anglong Studying Council was here.
I don't see their name in the cause list, my lord. That is what, my lord, I'm
He
concerned.
was here 3 matters.
Because factual aspect has to be, my lord, verified by the executive engineer, Karbi Anglong.
Find out if he's here calling.
Because only the factual aspect, my lord.
Just a while. Mr. Ronghang was here. Find out. Here.
My lord, I may be allowed to do it.
Huh?
I may be allowed to do.
Withdraw. Mr. S. Hawk.
My lord, I am appealing for the respondent 7, my lord, State Bank of India, my lord.
Sir?
Kedas, your lord.
I am for respondent number 6.
Number
6. 125.
4.
125.
1. The report, the report. Officer Kalia.
Published.
Lordship, here in this matter, we have filed our affidavit in opposition, Lordship, but the same is not on record, Lordship.
We want to find a reply, man.
Fine.
For which one?
4 weeks.
My lord.
Time. May file.
Reply.
Yes, Mr. Rom. This matter appears to be covered by judgment of the court.
My lord, maybe he is not aware.
Some time may be given, lord.
You serve a copy on him.
But-
A matter be called up next week.
The date may be fixed.
So our name may be shown in the post list, lord. SCKAC.
You go through it. You'll have it on 3rd of June. 3rd of June. name from standing down, Karbi Agno. Third of it's not right.
Obliged.
May I please, Lordship? My lord, this case relates to the non-payment of arrears salary from January 18 to December 19, my lord. And by this time, I got already retired from my service.
Ramin Vikas Bank.
My lord.
Ramin
Name has been reflected in the cause list. Some A Ganguly.
a counter file.
No, my lord.
We post it next week. Directly the respondent
On that date, hand over to me.
get the matter on 24. Right. Standing down. Ramin, the standing down Ramin Vikas Bank. The council of Ramin Vikas Bank. Not present. Okay. Contact parity. Complete their file and send it to them.
The personal recovery. Recovery from pensionary benefit. I'm
Write it for all.
there is a direction to take taxi service. I've taken taxi service, my lord.
Taken.
Yes, my lord.
But affidavit not.
My lord, the affidavit is not, my lord. Yesterday I filed it.
You filed it.
Yes, my lord. So, madam,
Then
next week.
Registry to verify. Trace out.
Highly obliged.
No, here the affidavit has already been filed, but I'm paying for an accommodation to them. Can it be on Tuesday and hearing them, or it will be closed, my lord?
The request of land account. That will be listed on 21st.
Highly obliged.
Then
Obliged.
they cut on here to the respond.
I please your lordship. Lordship, the respondents were directed to file their affidavit on many occasions, your lordship, but they have not filed yet, your lordship.
Lordship, we have filing our affidavit today. I'm appearing on behalf of Mr. S.P. Chaudhary for urban, for respondent number 2 and 3. Assam Urban.
It's submitted by the land account. That they are filing. We are recording it. They're filing the affidavit by today. And so therefore we listed after 2 weeks. Copies of the affidavit stated to have been filed.
Lordship, a date
Stated
may be fixed.
Stated to be copy of the affidavit that may be filed by the respondent. Be served on the council petition and reply affidavit. Based on 31st.
Okay.
The career won't be counted. You're appearing on behalf of
Mr. S.P. Chaudhary.
Yes.
Standing counsel.
Your pleasure, lordship. This matter, we have filed an IA, my lord, for stay of the recovery notice matter. It was, recovery notice was issued during the pendency of the writ petition, where the stay was granted. And in the last occasion, this honorable court has rightly pointed out that we have to file a mace case. We shouldn't file a mace case. But this matter is, my lord, necessary. This record is necessary for adjudication of the matter, my lord. We have filed in the way of mace case, my lord. My
There
lord,
is already an interim order.
yes, my lord, interim order is there. Interim order may be continued, my lord.
Where is
This
that interim order?
interim order, it was passed on 9/12/2022, my lord. And we have also annexed in the I, that is 1192. Page 12, my lord. In our I, page number 12, annexure 8.
Okay. But- and wait. It's. I, I, I don't appropriate. Stay off, where's the recovery? Page number
Recovery page number 15, my lord.
16, and it could be. That comes up there by order dated 9, 9/12/2022. Scored by issuing notice at
9.
order, staying the operation of the impugned order in original number 21 slash additional slash ST slash EHY slash 25 and 23 dated 5/7/2020. The next date. This interim order should subsequently extend. Was it extended or not?
Yes, it was extended, my lord.
View of this interim order, submitted that during the currency of the interim order, the recovery notice was issued. This is not recovery, this is for payment of arrears.
Yes, my lord. Payment of arrears for the, but in the affidavit, they have already stated that there is no pending tax and notice.
Is it recovery or payment of arrears?
Recovery notice, my lord.
Recovery for recovery seeking to realize arrears. Stated in the payment, right? The point which we notice has suspended the and during the currency of the investment, the impugned order, this order has been issued by the and therefore the IR right, right. It should be done at time till the next date. Since there is already an interim order operating by virtue of the order dated 7805. The tune the notification. What is the date here? 28/3/2024. Notice within bracket annexure between 15 state. Yeah, I have been listed along with. For the respondent,
CGST.
why no one is appearing? They don't serve copies.
Yes, my lord, we have already served. The last occasion they have appealed. Name is also.
So the council that has been served, but not represents the according to the council to the will serve extra copy in the minute of party.
Interim order.
Interim order has already been extended.
Yes.
Yes.
Obliged.
May it please your lordship, My lord, I'm appearing on behalf of Mr. SP Das for respondent 3 and 4. My lord, the government of Assam has filed an IA for recalling the order dated 31/8/2023. Due to an urgent meeting with the department, my senior Mr. SP Das had to leave urgently. So my lord, I pray for adjournment of this matter.
Your lordship, I have objection regarding the same lord. Two occasions, lordship, without my knowledge, lordship, the learned government council has taken time, lordship. At the time of mention, lordship, without my knowledge, lordship. Even lordship, the earlier lordship, honorable single judge.
Mentioning of what?
Lordship.
This is an IA filed by filed by them. This IA is filed by the respondent.
Yes.
So no order has been passed here.
Yes, lordship, but the original read petition, lordship,
Huh.
you was taking time, lordship, two occasions,
You are
lordship,
getting,
without my
you are
knowledge.
protected by an interim order.
No, lordship. Lordship, earlier, honorable single judge Bhaiti order dated 31st of August 2023, issuing continuing mandamus, lordship, whereby directed the compliance certain direction, lordship. As aggrieved the same, lordship, the learned government council has filed an appeal before the division bench, and honorable division bench Bhaiti order dated, your lordship, 23 of February 2024, lordship. Liberty was given to the respondent council, lordship, to place their view before this honorable single judge. Even lordship, one earlier lordship, honorable single judge had passed appropriate order, lordship, issuing continuing mandamus, lordship, whereby directed the compliance report, lordship, done. Now, lordship, another IA has been filed, which is prayer, lordship, to modification and alter the earlier judgment. So, lordship, it is direction has already been passed after proper observation of the dicta, lordship.
But this is an IA filed by them. No order has been passed here.
Yes, lordship, then your lordship, by for tomorrow, lordship, matter is urgent, lordship, by considering the urgency of this earlier honorable single judge has passed
Where is
continuing
that order?
mandamus, lordship.
What order?
Yes,
Which
lordship,
order?
tell me, annexer 12, lordship, page number 32, lordship, kindly be perused into their IA, lordship.
Yes. Please read
Yes,
the
yes,
effective
lordship.
part of the order.
Now I am reading only relevant point, lordship. Considering the approval of the finance department dated 20 and the last page, lordship, page number 34, lordship, relevant portion. Approval of the state government in the skill, employment and entrepreneurship department dated 22. It can be well presumed that the process of appointment of the last husband of the petitioner was approved on 22 itself. Had said appointment to the husband of the petitioner would have given immediately thereafter. He would have completed 1 year of service as grade 4 employee under Directorate Employment and Craftsman Training Assam at the time of his death on 22. As such, the Director Employment and Craftsman Training Assam respondent number 3 is directed to do needful for the purpose of giving the benefit of the compassionate family pension scheme of the state to the petitioner on the death of her husband, Popular Burman, in consultation with the Commissioner and Secretary to the Government of Assam in the Skill Employment and Entrepreneurship Department and further if so required with the Finance Department of the state as well as the Chief Secretary of the state.
Now, what has happened in this writ petition?
Yes, yes, Lordship. Then thereafter, Lordship, authority has not complied the same. Being aggrieved, Lordship, I have already filed a contempt petition and same has been admitted, but notice has yet to be served to the respondent authority. In the meantime, Lordship, and aggrieved upon such order, Lordship, the respondent itself filed an appeal before the division bench. Division bench has stated that, yes, that is opportunity upon you. You have to place if you any argument, then before the single judge. Now, your lordship, earlier observation is very much clear, lordship. Obita dicta has been Obita dicta, lordship. Learned single judge proper observation, lordship, and issue specific direction.
Very well, you pursue your contempt. Contempt has been filed.
Yes, lordship. In my contempt case, lordship, issue notice to the respondent authority. What is the bar, lordship? No stay order has been yet to be passed by the honorable division bench.
Pursue your contempt.
Yes. Yes, contempt petition, Lord.
Yes, you pursue the contempt. Is the contempt listed today?
Yes, listed along with this contempt, Lord. Item number 62, Lord.
Yes. Contempt. What is the stage of the contempt?
Contempt petition earlier admitted lordship. So lordship annexer B lordship
Taken
page
step-
number 12.
Have you taken steps on contempt?
So step yet to be taken lordship.
Why? Why? You take steps on the contempt, you
Yes,
file
Lord.
a contempt.
Yes.
Take
So today I will take.
Huh?
Today.
Let the writ petitions be listed after 6,
Yes, Lord. Date may can be fixed.
after 31st.
No. Deeply applied.
My lord, at the instance of the petition on this matter has been listed by mention, my lord, only for fixing a date for hearing. I am the first wife, my lord, and the second wife, in spite of there is a stay order, the authority has released all the benefits to the second wife. Earlier, there was an order to fix the matter for hearing. In the month of hearing, the matter was,
The directly listed in the regular hearing.
yes, my- in the month of March, it was listed, but the current there is no, it is not listed.
It is listed in month of June.
Fix a date, my lord, otherwise, not. In the meantime,
Come in the hearing list of June, you make a mention of the
in the meantime, they will file affidavit, my lord, otherwise,
they fight.
not filed,
The rule has been issued, no.
not issued.
If
Not
it
filed.
is admitted, or writ petition is admitted, let the matter be listed. Hearing list for meanwhile, the respondent may file the affidavit. If you don't file, we take it up.
Yes.
In states, the lordship finance department is to provide instruction as per your last order of your lordship.
Your Lordship, we have received the instruction, Lordship, here. As-
Whatever instruction has been received, can we get this in the form of an affidavit, lordship?
Lordship, here the problem, the issue is that the record is with the additional DGP only, my lords. The Lordship directs us, we'll file an affidavit in that.
Procure that file and file whatever information you require, file an affidavit.
Yes, Lordship.
CIT has taken the record.
Yes, Lordship.
You say that this record is necessary for filing the.
We have communicated, Lordship, now. Depending on some time, Lordship may grant us some time. In the meantime, we'll have to
File
expedite.
your affidavit.
Yes.
The council affidavit signed department that the record. Sitting the file BB dot 19 slash dot 5 containing the 50 message for BB of 190 slash number 5 slash 17 hyphen capital A dated 7/10/2005 is presently with the additional director and CI for investigation. The matter connected an investigation director in WC number 90/2012. He therefore some further time enable him
Okay, updated status.
to give the relevant
Yeah.
report and file again. Prayer made not objected by the other. But it is again
Okay, first week of June.
11 June.
Lordship.
11 June. I read it. Petitioner